Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is Telli versus Broward County.
Mr. Chief Justice, and may it please the Court, Bruce Rogo, Daniel Winger, and Eric Raymond for the petitioners in this case. The court below said that it is not a stretch of constitutional logic to conclude that a county charter may limit the terms of those commissioners it chooses to have. Our position is that this court's decision in Cook versus City of Jacksonville renders a decision below inconsistent with Cook and inconsistent with the Florida Constitution. There's no question that a term limit is a disqualification from office, and the court held that in Cook. There also is no question that county commissioners are, and this is the language from Cook, offices authorized by the Constitution, positions authorized by the Constitution, and constitutionally authorized offices.
I just want to go back to Cook, and I was in the majority in Cook. What we appeared to be doing was interpret what the voters meant to do when they passed the term limits for the legislature as to that whether they intended that the term limits would apply only to those statewide offices, or whether, and therefore no other offices could be term limited unless the Constitution was changed.
Correct.
Okay. And that was a voter initiative, the term limits, correct?
Yes.
If the voters had put in to the amendment the House, the Senate, and had added county commissioners, would that have been a single subject violation if they had done that? I know you probably. I mean, what I'm trying to figure out is how the intent of the voters to have term limited the legislature could possibly mean that they didn't intend to let the voters of home rule charter counties term limit county commissioners, because and you say, well, it's the same issue than it was for clerks of court or sheriffs or supervisor of elections, but those we always refer to, like the clerks of court, they refer to themselves as constitutional officers.
Yes.
We never refer to county commissioners as they're not constitutional officers in the same sense. So give me I understand what you're saying about Cook. I think this is something that could go either way in terms of how we are looking at the Constitution, but why we're compelled by Cook to reach the same exact result.
Well, in response to the first part of your question, I don't think that the fact that the initiative did not address county commissioners can lead one to conclude that therefore county commissioners are fair game for county limits at the county level. I think you can just look at the initiative and say this is what it focused on, and then you have to come back to what the Constitution says with regard to county commissioners and county officers. I mean, the two sections that are in play here are Section 1D, which was the Cook section, and Section 1E, which deals with county commissioners. But in response to the question that you're posing, this is what the court said in Cook. By term limit, by the Constitution identifying the offices to which term limit disqualification applies, the point that you were making, Justice Periente, we find that it necessarily follows that the constitutionally authorized offices not included in Article 6, Section 4 may not have a term limit disqualification imposed. If these other constitutionally authorized offices are to be subject to a term limit disqualification, the Florida Constitution will have to be amended to include those offices. So I think that the court addressed that in Cook.
Well, let me ask you this. Were the voters told that that would be the consequence of adopting that provision?
Were they told with regard to home rule?
Was that part of the ballot summary?
No.
Okay. That seems to me to be somewhat problematic, to have have the voters adopting an implied prohibition of which they are not told. Now, am I wrong?
Well,
let me ask you this.
Yes, Justice.
I'm not sure it matters. Because isn't it true that that Cook really rests on two independent grounds?
Yes.
And the first being that goes back to Thomas, where we said that you cannot add disqualifications or qualifications for an office where the Constitution has specified what the qualifications and disqualifications are.
Correct.
And so Thomas rests on that. Cook could have rested on that. So the whole business about the term limits initiative and the impact of that is really not necessary to the result in Cook, is it?
No. Well, let me say this. Thomas versus Cobb did lay the groundwork for Cook, and Cook spoke very specifically.
Well, that's what I was saying.
Yes.
That's the other basis for Cook.
Yes, the two bases. One is the disqualifications have been set forth in terms of term limits. Those are the only officers that are term limited, and so therefore, if the Constitution doesn't say anything about the other offices, we take a look at the language of 1D and 1E, and the language of 1E makes it clear that there is in 1E actually a disqualification. The last sentence of 1E: one commissioner residing in each district shall be elected as provided by law. So it added an additional disqualification in 1E.
When you look at 1E, I mean, it starts out with the language, except when otherwise provided by county charter. And it seems to me that by your interpretation of this, that language has no real meaning.
No, Justice Quince, because in 1D it says except when provided by county charter or special law. The two of them both have these exceptions.
Well, Mr. Rogo, but they're used in a different context. One is with regard to even the position. 1E refers to that you shall have that position. Under D, it seems to me, it's talking about how they're chosen, so that they're really totally different in D and E. Well, why is that not true?
Well, they are different in terms of where they're placed, but I think the difference cuts in favor of us, because I think that in 1D, it gives the voters the chance to abolish the office altogether. In 1E, there's no abolishment of the office.
But you can if it is under county charter. And well, isn't that what that language means? That you can, when it comes to county commissioners, that's what E is about, that when it comes to these county commissioners, really, the county charter seems to be taking precedent over even this statement about that follows in the rest of subsection E.
Well, Justice Quince, there's no question that this focuses on the 1G county, the powers of a county charter government. And of course, you dissented in Cook and focused exactly on that. But our position is that while the county charter gives certainly powers to the county to do many things, it doesn't give them the power to add a disqualification when the Constitution has not set forth that disqualification.
But when you look at this Constitution, unlike statewide officers, even under this section, Article 8, there are really no qualifications set as it is for the legislature, for the governor, for judges, for truly constitutional officers. And so it bothers me that we're trying to interpret qualifications and disqualifications in the same manner that we are for statewide officers when those qualifications are in fact set out in the Constitution.
I think the answer, and my best answer, really comes from the majority opinion in Cook, which does not draw the distinction that you are drawing in this discussion. And Cook, of course,
maybe that language is a little broad there, because I think it's a real distinction that when it comes to statewide officers, that we have the Constitution really laying out a lot more about their qualifications than we have in Article 8.
But of course, in Article 8, 1E, it does have a disqualification requiring the people to be who are running for commissioners.
With that, I would say that the charter would trump that, except if it's otherwise provided by the county charter.
And that's, of course, what the court below held. And, of course, I turn back to the D discussion, which also has that except language.
Except really, here's the problem I'm having, and I appreciate that Cook can be read very broadly. But there, you must have, under the Constitution, a clerk of court. Article 5, Section 16 says there shall be in each county a clerk of the circuit court who shall be selected. There's no requirement that you elect that clerk, and I think Miami-Dade doesn't have an elected clerk. So you can, but you must have those offices. They just can be chosen in any other manner unless it's specified. That's at least, now, that's how I'm reading it, that you could, let me ask you straight out. Could you, under the Constitution, could a charter county eliminate the clerk of circuit court?
Well, looking at the plain language of Section 1D, the answer, I think, is yes, or any county office.
How do you take, then, Article 5, Section 16 that says there shall be in each county a clerk of the circuit court?
Well, I think to do so then would pose a conflict with that aspect of the Constitution. But looking at this language, it does allow the abolishment. But, of course, that then gets you to the irony of how can you abolish it under this section when another section provides that it should be there. Of course, the clerk's officer is saying they're almost abolished now because they're not getting enough money. But the point is that I think that this is, when you look at the language of the Constitution, and that's what we're talking about in Cook. And I understand that Cook dealt with D and not with E. But there is, and I think this is important, there is a disqualification already in 1E that you cannot run county-wide. You have to run in the district that you're in. And I think that is very, very helpful in the analysis that I'm using. And certainly I'm relying upon Cook. There's no question that Cook, and as the court below said, Cook is this whole case. Everything here depends upon Cook and how you read Cook. And I think it also depends upon how broad the powers are under 1G. And in Cook, by the way, this court said that we do not agree with the First District's reliance on a charter county's home rule powers. So they discounted that home rule charter, that home rule power
aspect. They discounted it when there was an explicit provision that there only could be disqualifications for, and this is again what we're looking at is we use the word constitutionally authorized officers, and that's not a term of art. That was a term that was used by the majority opinion. So that's why I understand that we didn't say the home rule charter powers were so broad as to trump a disqualification, but we seem to be resting it on the fact that they were constitutionally authorized officers. And I guess, and maybe I'm falling into the Judge Gross trap, that I've always seen, like the supervisor of elections, they have statewide duties, as does the clerk of court. We can't function. The state couldn't function in their elections without a supervisor election. Now, you could call it something else, but they've got to be there. So and you're saying, no, that's not a distinction, but that's how I guess the 4th District was making that distinction. And the question is it an honest distinction, or is it we're just really talking around an issue that Cook is broad and therefore it has to apply?
Well, I think it's an honest distinction, but I don't think it's a persuasive distinction. And I think that when you look, and the reasons that the 4th District gave, the public policy reasons, I think actually cut in favor of the argument that I'm making. One of the things that the 4th District said, that there'd be a Byzantine bureaucracy that one would have to travail if you had different offices in different counties. Quite honestly, I think that it's a more Byzantine bureaucracy if you have different counties having different term limits and different understandings of the length of the term of their county commissioners. More business is done, because they were focusing on business in the 4th DCA opinion, more business is done inter-county than it is if you're dealing with the sheriff, or if you're dealing with the tax collector, or if you're dealing with the supervisor of elections. So when one looks at it that way, having uniformity in terms of county commissioners' term limits, I think is more consistent with the notion that everyone knows what the rules of the game are, people dealing with the county commission and the county commissioners themselves. So I think in a situation like this, again, obviously that the county home rule charters do not trump the Constitution. Article 4, Section 6 does talk about what the disqualifications for office are. This clearly is a disqualification for office. And in Cook, the language that was used certainly covers what we're talking about here. I understand the nomenclature. When we talk about constitutional officers, we think of certain kinds of offices. But in 1D and 1E, it talks about county offices. It doesn't talk about state offices, it talks about county offices, and then it talks about county officers. Both of them provide for an exception, but the exception does not provide in this situation for a county to impose term limits as an additional disqualification where there is nothing in the Constitution that allows it. So for those reasons, we think the decision below.
Could a county, through their charter, establish 12-year terms of office?
I think not. When one looks at this, staggered terms of 4 years, composed of 5 or 7 members serving staggered terms of 4 years. I think saying 12 years and nothing more, is that what you're saying?
I'm saying that it would establish that it would be 12 years.
I think that would be inconsistent with the language.
So that could not be done constitutionally.
Serving staggered terms of 4 years is what the Constitution calls for. So to say 12 years, I think, would fly in the face of that. Could
a large county, either geographically or through population, have more than 5 or 7? Could they establish 11 or 15?
Well, then we go to except when otherwise provided.
That's where I'm going. I mean,
right. But again, that would not impose a disqualification. If effective anything, it would enlarge the field.
Okay, so what you're saying, well, but a 12-year would not. A 12-year would reduce the number of people involved. So does this really then, when we start cutting and slicing this analysis, that it really comes down to the concept of disqualification as opposed to the actual words contained in the Constitution itself?
Well, I agree, Justice Lewis. This is a disqualification case.
I mean, is that the analysis that has to follow then? If not, we are reading out the first phrase.
We're not reading out the first phrase except for the disqualification aspect of it.
Okay, well, that's what I'm saying. So then it does turn on disqualification.
It does turn on.
And which clause in the Constitution addresses specifically in your view, this prohibition against disqualification?
The fact that there is another clause in the Constitution that sets forth what the disqualifications from office can be with regard to term limits. Okay. I'll save the rest of my time for that. That's Section 4 in the initiative.
You're talking about the section that talks about
Article 6,
the legislature
right.
and having term limits? Is that the section you're...
Yes.
Good morning. May it please the Court, I'm Joni Armstrong Coffey on behalf of Broward County. With me at council table are Chief Appellate Counsel Andrew Myers and Counsel for the Supervisor of Elections, Bernadette Norris Weeks. In Article 8, Section 1E of Florida's Constitution, the people of Florida reserve to themselves the ability by their direct voice in a charter to establish a governing body that invokes or assumes the entire home rule authority that was granted by the 1968 Constitution.
Could you go back to his very last comment? Because it does appear now that we're starting to get down to what the real essence is. And when we start separating all the other words, we talk about how long, that's not going to be a problem. Numbers, that doesn't appear to be a problem. But it gets to be a problem only for the disqualification. Would you respond to his position that the disqualifications or qualifications are found in the Constitution, separate and apart from these two provisions, and that's what's controlling in this case?
Justice, I think that is why Cook is something of an anomaly. Cook was the first time this court ever ruled that the direct voice of the people can't establish disqualifications. In all the prior precedent that petitioner...
Well, wait, that's a predicate statement that I don't know that I can even accept because the voice of the people is contained in the Constitution.
Yes.
So
yes,
you say, and so one must look at this to see what we believe it means because it's not always crystal clear. So, this predicate, I'm not sure that's there. I'm looking for the Constitution, not
right.
the nebulous. I hear lots of voices of the people, but they've written it here in this Constitution.
Well, let me see if I can respond as carefully as I can. Article 6, Section 4 articulates a number of disqualifications from office. Up until Cook, this court had ruled that the legislature may never add to those disqualifications. All of the cases up till Cook deal with the legislative disqualifications. And there's a reason that the legislature can't establish those disqualifications. Otherwise, they could insulate themselves and thwart the will of the people. But when we look at Article 8, Section 1E, that except when otherwise provided by county charter, we see something that suggests that Article 6, Section 4 is not the be-all and end-all of disqualifications, that the Constitution itself establishes a basis on which the people, not the legislature, can establish a disqualification. If, after all, they can establish the governing body that will exercise the home rule power that was granted under the Constitution as to local affairs only, they're establishing these offices. They don't even have to be county commissioners. 1C says they can be a governing body. And if they have all that power, why not the power to establish disqualifications such as term limits? And Justice Periente, when you talked about the single subject rule and the risk that, and Justice Kennedy as well, that the statewide voters may not have understood that they were foreclosing term limits when they adopted the statewide term limits in 4B, I think that is a distinct possibility because if you have at a local level the ability to have any length of term limit, which the Constitution plainly says can be done, then I think that if there is an 8-year limitation, if the people understood that they couldn't do that, then there would be an impact on multiple functions of government at a vertical level.
And it probably would have had to go into a separate constitutional provision. It seems that your real argument is that Cook was wrongly decided. And so are you asking us to recede from Cook because it was wrongly decided?
No. but what we are asking is that Cook not be extended. Petitioner actually asked the court to extend Cook. All we are saying is that 1D is different from 1E.
Now, but I guess the issue, because you were talking about the will of the voters and the will of the people. We have how many charter counties?
Approximately 20.
And how many have enacted term limits for their county commissioners?
Commissioner, a number of them, and I don't want to be, my estimate is 6 to 8. A significant number of them have adopted term limits, and they are different. Some are 2 terms, Broward's are 3 terms. Okay.
I guess the question is, since Cook came out in 2002, and it's 2012, since it was clear at least that it extended to everybody in D.
Yes.
Wouldn't the appropriate path have been to have amended or sought to amend the Constitution to make it clear because Cook is an interpretation of the Constitution, the voters can overrule that by changing the Constitution. Now, because it just, I'm struggling with how intellectually we can separate Article 8, 1D from E. So I guess the first question is, wouldn't the easiest thing have been to amend the Constitution to make that clear?
The difficulty with amending the Constitution is that you enter into a new expressio unius problem, which is that if you must amend the Constitution to allow term limits for that local governing body, then you have to amend the Constitution for any other disqualification, such as being an elector. There's nothing on the face of the Constitution that requires a county commissioner to be an elector, as there is with all other constitutional officers who appear on the face of the Constitution.
Is there some legal requirement that county commissioners be an elector or resident of the county in which they serve?
There is a residency requirement, which appears at the end of 1E.
That's in the Constitution.
That's correct.
Is there a residency requirement for the other county officers?
No, there is not. And that is one distinction between 1D and 1E. But returning to Justice Pariente's question on the difference between 1D and 1E, if you look at 1D carefully, both non-charter counties and charter counties can exercise the 2 powers that are granted there, which are to abolish or to change the manner of selection. 1E breaks apart home rule county commissioners or governing bodies from the other non-charter county commissioners, and it is, I believe, as the 4th District said, a default provision that the governing body will be 5 or 7 commissioners with terms of 4 years. So,
would you agree that there has to be a county commission?
I agree that there has to be a governing body. As the court is aware,
there's a statute that says there's got to be a county commission, right?
Well,
because there's a statute that gives, I think, 3 or 4 different options for charter county governments.
That's correct, and not only...
Is that constitutional?
I believe it is, because 1C says, as provided by general or special law, there shall be a governing body. But as the court knows, Jacksonville itself has a city council, a consolidated city-county government. That option is also provided under Section 3 of Article 8. And the statute that you refer to, Justice Kennedy, includes an elected executive who would sit at the same dais and can vote in the event of a tie or veto. So they're also part of that governing body. So
and you think that statute is constitutional because of what section?
1C. 1C is the core section that establishes this ability of the home rule electorate to access that home rule power that is granted by the 1960s.
Would you articulate the logical basis for carving out the 1E position from the others?
Justice, to me, it's this. Before 1968, the legislature exercised all authority over local affairs. In 1968, there had been something like 2,000 special bills filed in the 1967 session. And the people of Florida said, we're tired of that. We want to have a local legislature that exercises home rule authority over exclusively local affairs to the actual exclusion of the legislature. This court has said that the legislature is divested of power over exclusively local affairs. They become, in effect, the people's legislators over those things. And it's been so many years that sometimes we forget the power that this governing body exercises. They issue...
Well, I don't understand that, because what you're saying there, that the legislature can't... It's like the legislature doesn't have anything to do with that, but it says the counties operating under county charter shall have all powers of local self-government not inconsistent with general law. So I don't understand.
Well, what I'm saying is that if the legislature finds a statewide interest or finds a basis for general law, they can certainly apply that. And, of course, special bills are available, too, after a referendum of the people. My point to Justice Lewis's question is that these officers are different from 1D. 1D officers have to exist. They have to exist in some form. They can be brought in under the governing body, as has happened in Miami-Dade. But they're qualitatively different.
But I guess here's you were saying something about county commissioners don't have to be electors. Is that what you said?
It's not expressly required in the face of the Constitution, is what I say.
Does the other tax collector, property appraiser, do they have to be electors?
That is not required in the Constitution.
Okay,
either.
so that's not a distinction. Do they, under Section 4 disqualifications, Section 4A, no person convicted of a felony or adjudicated in this or other state to be mentally incompetent shall be qualified to vote or hold office until restoration of civil rights or removal of disability. Can county commissioners be felons and without having their civil rights restored?
Certainly not. We believe that 4A applies to all officers of the Constitution.
That's where the problem is because we've taken in Cook Section 4 of Article 6 and said disqualifications that because B, it could have been put in a different part of the Constitution, term limits, but it wasn't. And so it's there. And so if A applies, we said, well, B applies also as a disqualification, and therefore it applies, and I guess that must have been what convinced me back a decade ago that was a constitutionally sound basis for the decision. If that's constitutionally sound, then I think the distinctions you're making between D and E they're good distinctions, but they're not constitutionally valid distinctions based on our reasoning in Cook. Do you see where
I do, and I think there is a problem with Cook. I think that it's an anomaly.
Again, and I think that's what you've been trying. That's what you want. You really want to tell us that Cook is bad jurisprudence and we should recede from Cook. Isn't that what you're really telling us?
That is entirely the court's choice, but it is a difficult case because it is different from all the other precedent on which petitioner relies. And that's correct. And I think that there is a problem with assuming that the statewide electorate understood that they were foreclosing local term limits when they voted for term limits. And we've seen that the trend, as the court has seen in the Fair District Amendments cases, is not toward exclude. It's very positive for all the advantages that the proponents of term limits present.
Well, wouldn't we also have to, if you're kind of dancing around this, but you really think we need to recede from Cook? I mean, that would be the clearest, most intellectually coherent way to get to your position, wouldn't it?
If that's the will of the court, we would certainly be delighted with receding from Cook, but we don't think it's necessary.
You need to explain to us a way we can make a coherent, intellectually defensible decision. It's not, it's not just our will. It needs to be coherent and intellectually defensible. So, what's your position?
Well, Justice, it's this. I think that there is even less of a reason to apply expressio unius or preemption to these 1E officers because they have this local legislative authority. There's even less of a reason.
I guess the problem is, though, if the Cook part, I think that Justice Kennedy was talking about there are two bases for Cook, but to me the big basis was that disqualifications are exclusive and you cannot add disqualifications unless there's a constitutional amendment. I mean, that, as I reread it, that's really the underpinnings of it. And you said something about, and when I asked you, well, why couldn't, we've had a decade since Cook, And if the counties and the citizens of the counties think that this was, that they want the ability to enact term limits, a constitutional provision that says that county charter governments can also have term limits for any county officer would be the way to do it. And you were saying, no, we couldn't do that because then you'd have to do other things. And I wasn't really understanding what that response was, why that would be so difficult.
Well, let me clarify that. Once you say that there have to be term limits, this issue goes to the core of the selection of the officers for this position. And once you say you need a constitutional amendment for term limits, then what else do you need a constitutional amendment for?
Because it's only for disqualifications. And there's so few disqualifications, it's almost startling that you, as long as you can, walk and chew gum, and you're, not a convicted felon or mentally incompetent, you can, and over 18, you can hold any of these offices.
Let me unwind just for a little bit. I really want to stress
and I don't
that...
mean, what I'm saying is that there are very few disqualifications. I'm not meaning, obviously the electors pick people based on qualifications for office, but there are very few disqualifications in this state and the democracy in which that allow people to run for office.
Let me emphasize this. There really isn't, as the 4th District said, a statewide interest in how Broward County treats its elected officials and its position. Palm Beach and...
Well, that's a nice policy argument, but we're trying to deal with the Constitution.
Well, that's integral to the expressio unius and the preemption theory. That's the second prong. The first prong is there a pervasive scheme? And I would suggest to you there's no pervasive scheme for the reasons that we've talked about already, which is that these are different offices. But in addition to that, there has to be a strong public policy reason. And these are the governing officials that deal exclusively with these local affairs.
See, I don't think your argument really isn't a better argument. Really is when you look at D and E and you look at the placement of what the exception is, except when otherwise provided by the county charter, that exception is more pervasive than it is in D, which actually the language modifies a particular portion. When you look at D, you see that you can do another manner of electing these people. That's what the exception seems to say. And I think that might be a better argument for you than your policy kind of argument, because we really can't take into consideration the policy. We've got to take into consideration what the Constitutional actually provides for.
And that is exactly how we start with our argument, which is that there should be a reason that the framers created 2 different sections of the Florida Constitution. Otherwise, they could have put them all in one section. And they do use that exception clause very differently. It starts at the outset of Section E, and it says, except as provided by county charter.
Okay,
again,
but let me try
voice.
one more time. How does that get around that Section 4 of Article 6, which sets forth disqualifications, is the exclusive way that you can have disqualifications from any office specified in the Constitution?
Which is what takes us back to the expressio unius argument or statement of the court in Cook. And I would suggest that the litmus test that the court has always used on expressio unius for this pervasive scheme idea is, does the local term limit, detract from the other? Is there anything about the term limit in Broward County's charter that detracts from the statewide term limits that appear in 4B?
But wouldn't the same argument be for the sheriff or supervisor of elections? There's not really any state interest. I mean, somebody that serves for 8 years, then people may be for or against term limits as to whether that's helped in the legislative process or not. But the issue is that term limits became a very popular thing. So we're not saying that a supervisor of election, has to serve for 30 years versus 8 for them to be qualified, but yet the court said that because it was a disqualification, it couldn't trump Article 6, Section 4.
What the court has never said is that the disqualification has to appear on the face of the Constitution. Even going back to the old Thomas case and the other cases, is that the court has said there has to be a basis for it in the Constitution. And our argument, very simply, is the difference between D and E provides that basis, that Cook is distinguishable because these officers are different, they're treated differently, and that is our best argument.
Is a county commissioner a constitutionally authorized officer?
We believe for all purposes except Cook, and understand that the 4th District said they were not constitutionally authorized, but only for the narrow purpose of Cook, because the court was clearly struggling with the idea that the same voters at a local level could not place a disqualification that they can at the state level.
Constitutionally authorized if you're not a charter county. I mean, if it's a non-charter county, do they have to have a county commission under Section E?
No, they do not.
Okay.
They may be a consolidated city-county government. They can be anything else in which there is no statewide interest in establishing that body. And for those reasons, because it is a matter of particular local interest and within the control of the voters, we would respectfully ask that you affirm the decision of the 4th District Court of Appeal and allow the local voters to have term limits on their local legislators. Thank you.
To affirm the decision below, this court would have to, excuse me, to affirm the decision below, this court would have to recede or overrule both Cobb and Cook.
On Cook, and proceeding from precedent isn't something that can never, if it was wrongly reasoned or wrongly decided. We once started to recede from something about how we, about bonding, and you know the case I'm talking about, created a lot of unsettled concerns. If we were to recede from Cook, does it have any implications other than going forward that the other officers in D could be term limited if their charter provides for it? Does it have any other implications?
I think it would have those implications, and I think
But what else would it, what other implications would it have?
Well, you know, I haven't thought about all the possible things, but I think one of the troubles of interpreting a constitution is it opens the door to sometimes unforeseen results.
But if it's wrongly, if we really misread what the B part was, which was just the voters saying there should be term limits for statewide officers, people that are the legislators, the lieutenant governor, and there was no intent of the voters to preclude home rule counties from enacting term limits as part of their governance. I don't see how that. how that unsettles anything else. I guess is that if Justice Anstead was right in what he said, that we really did not pay due deference to the home rule charter powers. What other problem is there in receding from Cook other than your client doesn't prevail?
Well,
that's a big problem for your client.
I think it does pose a 1D kind of issue about term limiting the offices in 1D, the, quote, statewide offices that, while they're not statewide, they're viewed as county offices. But I think the most troubling is this language in Cobb, these plain and unambiguous specifications of disabilities exclude all others unless the Constitution provides otherwise. That's at page 183 in Cobb and page 93.
So when we also, based on that, if we recede from Cobb, we would, to reach the result adverse to your client, we would also have to recede from Thomas, would we not?
Well, Thomas is Cobb, Thomas versus Cobb. So
I'm sorry.
Yes.
I was hearing Cook when you said Cobb.
Right. So both Cook and Cobb would have to be invalidated, basically, in terms of the plain, simple language that they stood for. And I think that's the key to this. It is a Constitution we're interpreting. The Court has interpreted it, and this language has been very clear and clearly understood. And so I think for those reasons, the decision below should be reversed.
We thank you both for your arguments. We now move to the second case on today's docket, Antunes versus Sarasota County. Are you going to present argument at the same time? You agree, right? Okay.
We do agree. Good morning. If it pleases the court, Andrea Mogensson for the Appellants, Antunes et al. Versus Sarasota County. The core issue before the court in this case is an identical core issue to the one that was just under discussion. I hope to be brief and spend more time answering questions. The variation is that this is an appeal filed when 16 registered voters in Sarasota County were grant a non-final order from the 12th Judicial Circuit denying our motion to dissolve an injunction.
That injunction, could you just, the procedural posture of this was something that I find interesting, which is that the injunction was entered in what year?
2005.
So nothing was appealed in 2005.
Correct.
And so 7 years later, or whatever it was, 6 years later, somebody can just come in, dissolve the injunction, then all of a sudden resurrect a case that was already final?
Well, injunctions, by their nature, it's our position, and we took this position with the court, there's a retention of jurisdiction to the extent that the law changes and there's a change in circumstance. There necessarily must be a retention of jurisdiction. We moved for dissolution on that.
What changed in the law?
The change in the law in Snipes, in Telli versus Broward County and Snipes. Insofar as prior to that, and the Snipes decision distinguished Cook and actually created the basis for the argument today. That was specific to 1D. The question of this injunction was specific to 1E, county commissioners. That represented mandatory authority in the 12th Judicial Circuit at that time. The fact that nobody moved for a couple of years and let it lie dormant, I don't think prohibited our clients from recognizing that and then taking that step. So we did move to dissolve that injunction and apply the current law in place. That motion was denied, and that's how we got here today.
And the trial court judge there simply did not acknowledge the decision of the Fourth District.
Pardon me?
The trial court judge, in your case, chose not to acknowledge the decision of the Fourth District. Or did he distinguish it, or did he just that wasn't enough?
He denied it without rationale. So we're here without any guidance as to why that was, but we do agree with our colleagues from Broward County that the issue really comes down to the 1D, 1E distinction.
Yeah, I mean, it's purely an issue of law, so whatever pertains, is there any distinction between the Sarasota County Charter or the anything that would be an intellectual basis for your case not either rising or falling based on Telli?
Well, I think that what the case rises and falls on is the explicit language of 1E.
Well, that's but they're arguing the same thing.
Well, we've had a lot of discussion about interpretation of the Constitution, but the language is actually very clear that except is provided by otherwise by charter.
Maybe I just want to make sure. If you had sat around and not filed the motion to dissolve the injunction, and however Telli, whatever way it comes out, is there a way for Sarasota County to distinguish its situation from Broward County, either for better or for worse?
I understand the question now. No. The reason that this is here before the court today is there is a sense of urgency in Sarasota County insofar as we have a deadline of June 4th of this year for qualification for county commission. We have an incumbent commissioner who will either be qualified or disqualified by the court's ruling. The Second District Court of Appeals considered that a matter of great public importance.
Okay, but there's nothing in the charter that distinguishes it from the Broward County Charter.
No.
Yesterday, I received the notice of supplemental authority. Would you explain how you believe this enhances your legal position, the documents that you filed from the archives?
Yes, sir. The documents from the archives show that there was significant debate in 1966 when the Constitution was being amended with respect to 1D. There was at least 3 efforts and a debate regarding whether or not the same language, except as otherwise provided by county charter, should be used in 1D in application to constitutional officers that presently exists in 1E, applicable to county commissioners. We think that that's significant because it expresses that it was intentional. It's clear that there was some consideration, that was an important consideration. The policy rationale is a little less clear from legislative history.
Well, I'm not worried about policy. I'm just looking to how this may show me that that's the history behind this language. And there's no discussion, as I see it, in any of these pages between the 2 sections. Am I correct?
Correct.
And I do see. I mean, I see the language, the underlining, the strike through, and all that. So is that the extent of its importance? I want to be sure that I capture whatever it is.
To some degree, yes. I think the absence of debate with respect to 1E and county commissioners is what's significant. And I think that supports the argument.
How can I tell that from the papers I have? I can't see that 1E is even discussed anywhere in here.
Agreed, but the way, and I can't show you a negative either, but...
so that's what you're saying. Okay.
But
all right, I just thought
final,
maybe in these pages it would have told me that. Okay.
In the final outcome, there was a significant consideration of where that exception was going to be put in, that it was considered a significant exception.
Don't use all your time on that. I just want to make sure I understood.
And I think the majority of time is properly spent there, because what we're talking about is interpreting the Constitution. The intent of the drafters is clearly an important issue, and the absence of that debate with respect to county commissioners would seem to be reflective of something. And the court should give consideration to what that's reflective of, presumably that the 1E commissioners are subject to the home rule in 1G. It does not seem to be a coincidence that in that legislative history, that is where 1C was added for the first time, and that counties were allowed to enact charters for the first time on a statewide basis rather than by special law.
But I guess you agree there that the D officers and the E are constitutionally authorized officers, correct?
Well, I believe that the 1D officers are the constitutional officers that were under consideration, and clearly they're the constitutional officers that were under consideration in this court's Cook decision. There is a distinction, as was the 4th District Court of Appeals indicated in their analysis in Telli versus Broward County and Snipes, that from a colloquial and a legal point of view, constitutional officers are 1D officers, that county commissioners are not widely regarded as such.
But the basis of Cook was that disqualifications are exclusive and can't be added except by amending the Constitution. So although I appreciate the distinction, and I think there is actually a pretty big distinction in the constitutional officers of D than E, I don't know how that is legally significant for the purpose of the underpinning of Cook, which is the disqualifications are exclusive and cannot be added except by amending the state constitution.
I think that this court could grant the relief requested in this case functionally by both parties, with either by receding from Cook or consistently with Cook. And the reason being that Cook, at the end of the day, stands for the proposition that you have to look to the Constitution, the specific provision under discussion, to determine what its meaning is.
No, but again, and maybe we're just going to go around. To me, and I must, as I said earlier, the most compelling reason, and it's Cook and it's maybe underpinnings in Thomas, is that we treat disqualifications different than qualifications. For any officer that is governed in any way by the Constitution, and certainly county commissioners are the idea that you have to have a governing body for a local, for a county is there as, we're not dealing with mayors or city government. We're talking about county government. And I don't know how you get around that the term limits is a disqualification for constitutionally authorized officers. We didn't just say we could have talked about the different levels or different sections, but for D and E purposes, they're both constitutionally authorized officers, aren't they?
Well, to the extent that all law is authorized by the Constitution, but I don't know that we can say from what we can read in the Cook opinion that that's the case. And I don't know that we can say that that's the case because while the Constitution mentions and authorizes, it authorizes the officers except as otherwise provided by county charter. That would suggest that an amendment is not necessary because the language is already clear. And I don't think that you necessarily have to if the requested relief is granted, to find that it's receding from Cook, although it could be. Given the language in Cook, which is a reiteration of the determination in Cobb, that the Constitution is the charter of our liberties. It cannot be changed or modified by legislative or judicial fiat. It provides within itself the only method of its amendment. This particular provision does not require that amendment for the court to grant the requested relief. This particular provision states, except as otherwise provided by county charter. This is the exception.
Do the officers in this case come within that which was excluded, expressly excluded from Cook, when this court said we do not address the validity of a term limit provision upon an office authorized in a county charter, but not authorized in the Florida Constitution?
I think that's a very important question because the answer is somewhat of a hybrid, because although the county commissioners are mentioned and are derived from 1E, that specifically the preamble language in 1E that says except as otherwise provided by county charter appears to be a constitutional delegation to the county to regulate the commissioners.
How are the commissioners structured? Are they called different? Are there different terms? Tell me, what other distinction do you have in your case?
I think that is in our particular factual case.
Or these cases.
I think that it's less of a factual distinction than it is actually the constitutional distinction.
Well, Cook dealt with different offices, didn't it?
Right, but
so it can't be within that decision.
And no, that is sort of the point du jour, I think, that the Cook decision does not address 1E officers at all. And it's unclear whether Cook would have been decided the way it was had that been part of the question. That we do not know because the 1E officers, the county commissioners, were removed from consideration by not filing an appeal out of 8 is enough versus, I believe, is Pinellas. That could have been a subject before the court. It was not. So, from that point of view, this would appear to be a case of first impression, the first opportunity to look at 1E, but I'm not sure that it's appropriate to interpret 1E when 1E is so abundantly clear that except as otherwise provided by county charter, this is the default structure that applies. Cook does contemplate that there are exceptions to the provisions, disqualification provisions, the provisions in the Constitution, and it points those out in its notes. I would agree with my colleague that 6 sub 4 sub B is not the end-all be-all, especially in a circumstance such as this, where Article 8, Section 1E is so clear that this is one of those exceptions. So if I may reserve the rest of my time for rebuttal if necessary, I would be grateful. Thank you.
I don't think you're going to be rebutting.
Yes, I put my foot in my mouth, Mr. Chief Justice. May it please the Court, I'm David Pertson, Special Counsel of Sarasota County, and I am in the unusual position of saying I agree completely with the appellant, and term limits are appropriate in constitutional provision of the Sarasota County Charter. Let me tackle some issues that I've heard this morning. We've heard about, from Justice Quince and Justice Lewis, the question about that first phrase in 1E. That has to mean something. The except as otherwise provided in a county charter, that has to have some import here. And as Justice Parente said earlier, as she parsed 1D, it's a different structure. It says we shall have these people, and then accept, and then you can remove them or change their offices.
So does that language mean that if county commissioners are provided for in a county charter, that nothing in E is then applicable? that only what is provided for in the county charter is applicable. Is that what your argument is about that language?
I think that sentence in my mind means that except for otherwise provided for the county charter is applicable to the number of commissioners that can be there and the terms of office that can be there. And term limitations are a function of the term of office. So that section is what what I guess the Telli court said it was the default provision. And if you practiced, like as I have occasionally, condominium law, there's a default provision in condominium laws is if your declaration of condominium doesn't cover it, then the statute applies, and this is what we're going to do. And I think E is the same thing. If the charter is silent, then you're going to have 5 or 7 commissioners. They're going to be 4-year terms. They're going to be staggered. But our charter isn't silent. Our charter is 5 commissioners, 4-year terms. You've got to take 2 years off after 2 terms. So I think that's a significant difference from D, which says you shall have these people and accept. And it uses it, my 8th grade grammar teacher would be very proud of me, but when she beat into me the use of semicolons, colons, and periods. Because with a semicolon or a colon, you can put a period there, and you can create 2 sentences. You use a semicolon and a colon when the thoughts are together. And if you read it that way, it becomes even more clear that there are these constitutional officers, and you shall have them, period, except that you can remove them under these circumstances. And that's significantly different than E. And that's the difference, and that's the distinction with Cook. And that's why I don't think...
I don't understand how that is relevant. I mean, I understand these are different provisions. I mean, it's obvious. There's some differences here, and these different offices are dealt with in different ways. But I don't understand how that is relevant to the question of whether the charter can impose a qualification or disqualification that's not in the Constitution. I mean, and again, I'd go back to Thomas. I guess that's Thomas versus Cobb. And I'm struggling with how we can decide this in a way that's favorable to your position without proceeding from Thomas versus Cobb.
Okay, 2 ways I think we could do it. One way is to read that except when otherwise provided by county charter as being a default provision. It sends it back, that specific language of 1E, which has never been reviewed, sends it back to the charters and lets the voters of the counties, in our case Sarasota County, make that determination of what if any, term limitations they want to put on that. That's way number 1. Way number 2 is to, in the unfortunate event in our position that if you expand Cook to cover the county commissioners, then if you look at Cook says all disqualifications are contained within Article 6, Section 4, except it drops a footnote 9. And footnote 9 says, well, there are others scattered throughout the Constitution, ages for justices being one, the governor being the other. Well, I would make an argument that this is yet a third, and this is a express delegation back to the locals to make their decision under 1E, under Cook. So I don't think you need to recede from Cook. You simply,
I was actually talking about Thomas versus Cobb.
Okay.
I mean, which is back there further than Cook, and I think it really has, it represents one element of the reasoning in Cook. But if I understand what they were saying in Thomas versus Cobb, they were saying, look, in the Constitution, we say what disqualifies somebody from being a state officer, county officer, and require a school superintendent to have the certificate of an educational credential that the legislature wanted to require goes beyond what's in that requirement in the Constitution. And you can't do it because we've said this is what it must be, and you can't say it's got to be something in addition to that. And it seems like to me that the reasoning there kind of fits the circumstances here.
I need to look at I think Thomas...
I will candidly say, I think that reasoning is subject to challenge because it is I think anytime we get into implying prohibitions on either the legislature or some other entity that's recognized in the Constitution to have broad powers, such as the charter counties, then that raises some questions. So, well, how can we be sure that was necessarily implied? So, but put that aside. I'm having trouble understanding how we can reconcile the reasoning of that opinion with the result that was reached by the 4th District.
Well, we're going to need to look at also, I believe, Mr. Chief Justice, the timing of 1E and when 1E was created versus the timing of Cobb, and I don't have that in front of me to respond to that. Is the language which has accepted as otherwise provided by county charter in existence in 19...
Cobb is quite old.
Right.
I mean, Cobb is from the 50s. Cobb comes from March 28, 1952. Before even I was born.
I need to look at. I don't have that answer. I don't have that answer in front of me. But that's the question: is what did the Constitution look like when that was decided vis-a-vis this, what I call the exculpatory language, or what the 4th DCA called the default provision.
But it also seems to me that this is the first time we've ever directly addressed this exclusively county position.
Right.
Circuit judges to resign to go to Supreme Court. I mean, these are all statewide kinds of functions. And we do in Cook say specifically that it's 1D. We may throw in constitutional office, but it's always in connection with the 1D offices, it seems to me.
Yes, sir. And the question then is 1E, are county commissioners constitutional offices as we tend to know them? And we would suggest they're not. I mean, colloquially, as we all know and is recognized in the 4th DCA, your constitutional officers are those very proud people, the clerk and the sheriff and all those good things.
But it's obviously an office that's authorized by the Constitution.
It's recognized by the Constitution. It's a default provision. I mean, you don't have to, again, you're kicking it back to the locals to make the decision. I mean, that's how I read the first clause of E.
Let's go back, though, to, I think I asked this question in the first oral argument. I just want to make sure that under Section 4, Article 6, disqualifications, could a county charter trump the provisions of Section 4A as far as who can hold office in a county position?
Well, two ways to think about that. One is if you determine that they're not county authorized, then Cook doesn't apply, and then Article 6, Section 4 doesn't apply.
So your argument is, because Broward County attorney stated that, no, 4A would still apply. You cannot be a felon with your civil rights not restored and hold office at for a county position.
Having practiced in Louisiana, I used to think that was a requirement, but yes, it would apply in that sense. I agree with you, Your Honor.
Okay. Could the local government, charter government, impose a qualification or disqualification that nobody over the age of 70 could hold office as a county commissioner?
If it did not violate any other act of the federal or state law, it could, Your Honor.
So that wouldn't be so that's not a disqualification, being over age 70?
Well, it would be a determination by the voters of that county that they'd be able to determine the term of office and the county commissioners. If it was an age, you'd have to extrapolate that to be whether it's a part of the term or not, and I would say it's not. So it would be an in answer to your hypothetical, it would be probably be an impermissible disqualification of office.
It would be an impermissible. I'm sorry, you said so. It would be impermissible to do that.
That's correct.
The only way to do that would be to amend the Constitution.
That's correct.
So again, I guess we go back to this core issue, which is that term limits are part of the disqualification section exclusively and sets forth the people that cannot serve more than 2 terms.
Well, then that brings me back to my second point, and that is that if you view Cook as applying to county commissioners, and if you view Article 6, Section 4 as applying, then I would make the argument that phrase in 1E, except as otherwise provided by county charter, is a direct delegation back to the county on the disqualifications that they wish to add, which are otherwise permissible by law, as to the terms of office for county commissioners.
Is it clear that under a county charter, you can lay out the qualifications for a county commissioner, or whatever you want, even if you didn't call them county commissioners, because I I think under that E, you wouldn't even have to call them county commissioners. You could call them whatever you wanted to. You can set out the qualifications for who can hold that particular office. Is that correct?
Yes.
Okay. And so it just seems to me that we're getting into a lot of, the qualification versus disqualification. Isn't a disqualification the other side of a qualification? I mean, it seems, you could say that anyone is eligible to hold office up to age 70, and that's a qualification. But if you say you can't hold office after age 70, it becomes a disqualification. Yes. It just seems to me that we're doing a lot of wordsmithing here with qualification and disqualification.
This is a friendly question here. If
Watch out.
I know. I'm gripping the podium.
If the supervising body were called, say, county counsel, would they still be a constitutional officer?
Yes. Well, under 1D,
yes,
you can change their office under that second.
You can call it whatever you want to call it.
You can call it.
Just because the Constitution called it county commission does not necessarily mean they have to be that.
Well, if you're a supervisor election, and
I'm talking about the county commissioners. We call the county commissioners county counsel.
Yes, sir. Yes, sir. You can. Your governing body is a. You're right. It was a difficult question. You warned me correctly.
That's invariably the case.
The right to change in the charter under 1E vests with the number of county commissioners and the number of.
But you can call it what you want to call it. Is my only point. Just because it's mentioned in the Constitution as constitutional officers, that in itself does not make them constitutional officers. Because of this exception, the default. And 1E.
I believe you could call them something else, yes, sir.
Okay. So that's permissible?
I believe so, sir, yes.
What if Sarasota call them?
Sarasota calls them commissioners. If there are 5 county commissioners elected for 4-year terms.
But isn't that...
In Duval County, which is mentioned...
Silly, don't you think?
Duval County, well, no comment to that question, sir. In Duval County is merged, and of course we haven't brought that up because there's a whole series of constitutional issues concerning how that was done from 1934, and there's a special recognition. But they have a whole different system of government that has been consolidated, and county commissioners are gone in that situation.
Let me ask you this. Did I understand you to say that under a charter, county charter, the disqualifications in Article 6, Section 4A could be eliminated? That is, that a county could decide, we're going to have felons who haven't had their civil rights restored eligible to be commissioners.
No, I don't believe that's true.
You don't think that's true?
Right. You first were
yes.
starting to say, then you thought better of it.
I caught myself, Justice. I realized I was no longer in Louisiana. Thank you.
We thank you very much for your arguments. The court will now take a 10-minute recess.
All rise. Fourth Supreme Court is now in session. Please be seated.
We now take up the third case on our docket, Davis versus the State of Florida.
Thank you. Good morning. May it please the court. My name is Paul Patello, Assistant Public Defender on behalf of Rston Davis. I'd like to talk about the first three issues in the case, but because they have a common thread, I would just like to briefly describe them. And the common thread is that Davis invoked his right to remain silent. Davis invoked his right to remain silent, yet the state put evidence of that before the jury. Davis invoked his right to remain silent.
Now, what was the evidence that he invoked his right to remain silent that was before the jury?
On the DVD, the detective saying, before we go on to talk about what happened here tonight, I need to go over your rights, right? Under the law.
Does it show what he said in response to that?
Remain silent is what he said in response to that.
But it was an error. I mean, nobody intended for that to come in.
That's correct.
Okay. So the other question I have about whether it would be, in this case, be considered harmless error is, didn't Davis take the stand?
No.
He took it only in the penalty. Did he take it at all?
Right. He took it in the penalty phase.
Okay. So he didn't take it. Okay. But what did the prosecutor? When was that discovered that something had gone back to the jury that had a part of the tape that the judge had granted a motion in limine on?
I think on appeal, to be honest.
Okay, so it was never argued to the jury, anything about the right to remain silent?
No.
Okay. And neither side knew that had happened. The judge had said it couldn't come in, and specifically it wouldn't come in for the expert on mental state for the
correct
to say,
correct.
Well, he invoked his right to remain silent and to ask for an attorney, therefore he must not be insane.
Correct. That was all excluded. It was excluded.
But wasn't that, even though it was excluded, wasn't that a basis, part of the basis for her determination that is Dr. Butt's determination that Mr. Davis was not insane?
Yes, but it was clear because under this court's precedent and U.S. Supreme Court precedent in Burdick and Greenfield that doesn't come in. The evidence of silence does not come in. So it was excluded, although she would have, if she were allowed, she would have testified it factored into her opinion.
So now we go to something that's different here, which is that the defense wasn't that he didn't do it.
Correct, it was insanity.
So what you would say is, in terms of whether it would be harmless error beyond a reasonable doubt, that we don't know that the jury could have looked at him having said what he said and sort of said, well, he couldn't be legally insane if he asked for an attorney?
That's right.
But that's speculative, isn't it?
Well, all trial errors in that respect are speculative.
But this is, I guess, and maybe I'm having trouble as far as this being a trial error. We again know the judge made the correct ruling.
Right.
And the defendant relied on that ruling but didn't look at the tape before it went in.
Well, that's not quite accurate. He was shown that it was correctly edited. He was shown it was correctly edited. The prosecutor, I readily concede, did his best to keep this out. And he was so concerned about it that before that portion was to be reached, he took defense aside, this is on the record, and wanted to double check it. So I don't think defense at all can be faulted here for assuming that it might be reinserted later.
Well, how did that, I guess my question on it, if the jury, they were, a videotape was played.
Correct.
Of his conversation with his parents, and I know that's your second thing, but they never, during the trial, they never heard him say, I'd like an attorney and I'm made
That's right.
So how did it, do we know how it happened, that something that wasn't in the tape at the time of it being played to the jury ends up in the tape later?
No, we don't know how this happened.
And we don't know if the jury even, how long was this DVD?
2.5 hours.
So we really don't, do we know that the jury even played it when they got back into the jury room?
I would assume so. That was the first thing they asked for, was the DVD. They got a DVD and the DVD and the player, and they had both during their nearly day-long deliberations. So they had plenty of time to watch the DVD again and again.
Well, now let me ask you this about this DVD, because I'm a little bit confused here, because I thought even when it was played at trial that there was some portion of it that was beginning to play that should have been redacted, and then they skipped over it. That didn't. How did that all play out at trial?
Yeah, all we have from the record is this, that the inadmissible portion occurred between 4:35 a.m. and 4:40 a.m., and the prosecutor, it looks like, did a good job of cutting that out. But from 4:40, the DVD played till 5:13 a.m., and that's when it skipped back to 4:25 a.m.
So the portion that should have been redacted.
To before that portion. And this did occur, during trial, if that's what you're asking, Justice Quincy,
yes.
That's probably what you're referring to. And the prosecutor and the detective are sort of puzzled by this. And the prosecutor has the detective advance it beyond the inadmissible point, beyond it, to 5:55 a.m. But I'll say this, too. There's another part of the record, which is on relinquishment. And the prosecutor said at that point, he thought, I think the quote was, he thought it was the blasted machine jumping back and forth. That was giving us trouble.
Well, let me ask you this. Since that did happen at trial, and the defense attorney was well aware that for whatever reason that was spliced in where it shouldn't have been, was there any obligation on the defense attorney's part to make sure that the DVD that was being sent back to the jury didn't have that jumping back portion in it?
Well, a couple of responses. One is he could have been like the prosecutor, that he just thought it was the machine jumping back and forth. And second, even if
how does the machine jump back? If the portion was taken out, then why would the machine put it back in? I'm having a problem.
Well, you're not the only one, believe me. As the prosecutor said on the relinquishment hearing, this portion miraculously reappeared. It was miraculously and magically reappeared. But he even attributed it to the ghost of Rosemary Woods.
Yeah, but notwithstanding, the real question in my mind is, because it miraculously appeared, was there any obligation on the part of the defense attorney to make sure that the tape that was being sent back to the jury didn't have this miraculous portion on it?
Well, I think and to answer very quickly, that's asking too much. It's really asking too much. But just think about it, too. If at 5:13 all of a sudden The DVD is going back to 425. And even if it had occurred to the defense attorney, well, this DVD is going to continue. It's going to go 425, 426. And what he'll think it's going to do at 435 when the rights begin again, I would assume he would think it's just going to jump over it so seamlessly like it had before. As he said on relinquishment, I had no idea this would, I never dreamt that this would happen.
In the presence of the jury, were any excluded portions played to the jury?
No.
Did the jury hear anything?
Not in the jury, not in the courtroom, no.
So they caught it in time in front of the jury?
Well, they thought they had, and they did initially do a great job of editing that portion out, and they thought they'd done it.
No, but while I was explaining to the jury that we had these technical problems,
okay.
they were able to catch it in time before the jury heard anything about him.
Yes.
So your concern basically is when the tape went back to the jury room during the deliberations, that there was no one back there to sort of redact that out.
Right. And as I say, as I've outlined, especially in the reply brief, there is a presumption that the juries carefully review the matters that are sent back to them in the absence of proof to the contrary.
I guess I still want to kind of go back to this harmless error. Mm-hmm. Because in my view, I think that if anyone had the obligation, it's the prosecutor. I think it's just under these circumstances, and it looks like everyone's blameless, and certainly the trial judge didn't want it to happen, and the prosecutor wasn't trying to get around the trial judge's ruling. That's pretty clear, and you agree with that?
Correct. Oh, yeah.
Is it different, I guess? We have always called comments on the right to remain silent high-risk errors. This wasn't a comment on the right to remain silent, correct?
Yes, but
let me just, again, invoking your right to remain silent, which is a constitutional right to remain silent under the Fifth Amendment. If you have a case where it is an issue of the guilt or innocence, isn't that different in terms of assessing the nature of the error than when it's the legal insanity?
Well, to my mind, it's much worse than an insanity case, because I think a jury could ground its very decision in rejecting the defense on the notion or the view, common sense view. It's what many prosecutors thought, the view that someone who was insane would not have invoked or could not have invoked their rights. That's why it's particularly harmful in an insanity case. And I think the answer to a harmless error analysis question on this issue is Guerin, because in that case, although the evidence was presented in open court, what happened in Guerin pales in comparison to this evidence.
What happened when the jury requested the tape to hear the DVD? And was there a discussion among typically when that happens, lawyers argue back and forth with the judge. One side wants it in, the other side doesn't want it in. Was there any discussion or any reminders to the judge, we had that problem, Judge, and remember, there's not going to be someone back there, skipping the tape over for them?
It didn't.
Did the defense counsel object to that?
Register to anybody. It apparently didn't register to anybody, the judge, the prosecutor, except for that comment I have in the relinquishment where he thought it was the machine jumping back and forth. No one had any clue this happened. No clue.
So what happens is you're looking at the record on appeal and the tape, you look at the DVD and you go, where's this coming from?
Yeah, holy cow. Look at this. This is
on
very
the
inadmissible.
holy cow issue. I don't. You said you were arguing the first three issues. I'm concerned about the transcript issue. Is that one of the issues?
That's number 3, correct.
You argue, and I don't have the exact quote here, that the statement that that he was using cocaine could have been interpreted to that it was a different. It didn't say that.
Right, the opposite of what they claimed he said.
But the transcript, when was the transcript provided to the defense lawyer?
The final version of it was provided right before it was handed out to the jury.
So is it that, and again, I know this is this issue about who should be looking at it, but at any time other than you stating this on appeal, did the defense, I mean, they must have listened to the tape, and they don't have an obligation, but they could have had a transcript prepared of what they thought it was, and if that seems to be if that's a disputed issue, focusing particularly on that. They didn't do that.
Correct.
And I guess the question is that in terms of, once again, trying to figure out who should bear the burden, you're saying, well, it could have been that, but the record below really doesn't establish that was a disputed area. I mean, they didn't want the whole, they thought at some point all they were doing was looking at the transcript, and that was certainly a problem. But as far as that particular statement...
Well, I disagree with you on the part that this was not disputed. I think it was disputed all the way along. And just to give...
You mean the exact statement?
The cocaine in my system statement.
Well, so since the defense lawyer knew that would be disputed, wouldn't there be their obligation in terms of telling the judge that should not be in the transcript? They should have been focusing on that. And again, I know that when we're dealing with these cases and we say something, shouldn't the defense lawyer say something? Somebody out there saying, post-conviction. And so it's not a pleasant situation to be in. But on this one, it just seems that, again, this was a 2.5-hour DVD that played. So there was 2.5 hours of transcript.
Correct.
That if that was the big issue of the translation, shouldn't somebody have alerted the judge that part should not come in as the transcript, the accuracy of that part of the transcript?
Well, I can tell you what defense counsel did do, and you'll be the judge of whether it was enough. But this issue first came up when one of the defense experts testified, Dr. Ribbler, and that's when the prosecutor had his contention, and he questioned Dr. Ribbler about, did you hear Davis say on the DVD that he had cocaine in his system? And the defense objected and said he knows there's a transcript to that effect, but he's not agreeing it's accurate. It's at that point the judge started this ruling, which he made like 3 times, and he made this ruling to each objection to the versions of the transcripts as they're coming along. And the ruling is it's a weight issue. It's not, and the jury, he will be instructing the jury on the use of the transcript, and they will be the ones who will decide. It's not up to me to decide. But
okay, that's what the defense lawyer did, but he didn't say, Judge, you need to, under Martinez, review that portion of the transcript because it's really questionable that he said that.
No, he didn't do that. Right. He didn't do that.
Was there any other than that statement? Because clearly, if it came in and it's inaccurate, it's quite harmful. I mean, I would agree with you on. I mean, that the transcript then trumps the mumbling that's heard. Was there other? And the state's theory was he was psychotic, but it was because of cocaine.
Right.
Was there any other evidence that he was on a cocaine high that night other than this garbled statement that he made to his parents?
Nothing other than that he had cocaine in his car. But so that was explained by his... So
did any expert, nobody talk to... Well, but the observations of how he was acting that night, didn't the state experts say those observations are consistent with somebody on cocaine? Yeah,
the state's expert, Dr. Butts, testified that although she couldn't rule out that it was organic psychosis that caused this behavior, she thought the better explanation was drug-induced psychosis.
Well, there was evidence that this defendant was a dealer.
Correct.
A trafficker in this. I mean, it's not as though this is the priest that is behaving erratically and that kind of thing. So, I mean, the access to these substances or this substance Was established.
Yeah,
his connection to them.
Yes, that's correct. But I admit quite readily he was not a priest. But I will say this, that nearly every witness described Rston Davis as not just not having evidence of violence in his past, but that he was positively peaceful, a peaceful
he just sold
person.
Drugs.
Pardon?
He just sold drugs.
Well, I'm not condoning that either. I'm not condoning that.
There was
either.
no evidence that he was a drug dealer, that he was a user?
There was no evidence he was a user, and the evidence was the opposite, that he didn't use cocaine.
So and I thought, and this is really something I'd ask Ms. Campbell about, the statement of saying to his parents, and I had cocaine in my system, doesn't even, I mean, that seems like a bizarre thing for somebody who's still acting erratically to say. I mean, that was, but again, my problem is your interpretation of what he might have said, which was, what have you come up with now?
Well, you got to put the background. It's on page 60 in my brief where I go through it, but they're talking about the newspaper's report that people who die after being tasered have cocaine in their system, which the defendant, Mr. Davis, initially poo-poos that notion. But then he says, you know what, they might be right.
That's what the
newspapers might be right.
And that was, why were they talking about what was in the newspaper?
Because I think at that point in the discussion, we're talking about Davis having been tasered, because he was tasered when he was arrested. And that's where that was coming up. And he was,
was he worried that he was going to die because he had cocaine in his system?
No. They, in this little family conference of a wide-ranging discussion, and as I pointed out in my initial brief, the mother and the father are obviously concerned and distraught about their son and what's happened. And they know something's terribly wrong with him, terribly wrong. And they're trying to find out why, or, the explanation. And that's like I put it out in my initial brief, 5 minutes before this cocaine in system part of the DVD. 5 minutes before that, the mother asked him, you smoke, Junior, what you do? She's trying to get out. And he has this visceral reaction that he's rejecting, he says drugs. It's like kind of, I know I don't use drugs. I don't use drugs. The mother took that clearly as a denial because she asked him, well, what's wrong with you? So she's trying to get at what is wrong with him. And that's why I say more importantly, let's throw away my attempt at transcription. 5 minutes later, when this discussion comes up, if he had said he had cocaine in his system, she would have followed up on that. She didn't follow up on it because he didn't say that.
Did she testify? If she was a witness to the statement, did she testify?
She testified in the penalty phase.
But again, I think that's an opportunity lost, that if she thought it was something else and she knows his syntax and him better, isn't there some obligation to refute what to say the correct thing that he said was such and such?
Well, there's a lot of things that could have been done better in any case, I suppose.
Yeah, and I'm just saying, we have to deal with what we would look at again. You've got a transcript.
Yeah.
The state goes to trouble putting a transcript together. Obviously, the defense knows they're arguing cocaine, and that, as you said, a witness had already relied on it. Be the one thing, if there was a different understanding of what he said, to put that forth through the mother or to do and that's my problem with what your argument is.
Yeah,
here.
I know, but my problem, or the point 3 that I've raised, is in Martinez, this court came out with procedures to follow, and the very danger this court sought to address was that a transcript given to the jury as an aid might have incriminating statements that cannot be clearly heard. So this court put together a list of procedures to follow. In McCoy, which was decided again before this case went to trial, this court again mandated those procedures, and they weren't followed.
Well, did the defense object to the absence of any of those procedures specifically.
He objected and disputed the prosecutor's characterization. He said initially, when Dr. Ribler testified, I know there's a transcript to that effect. We're not agreeing
Again,
it's true.
As I look at this, the straight answer is that he didn't object that the officer was in the room and then also monitoring it, which is a requirement. He didn't object that the trial court did not independently verify, because the officer who did it was asked, and he said, yes, I verified it, corrected it, and that kind of thing. No objection at that point, just that it ought not come before a jury because it's going to act as the evidence rather than the tape. Isn't that really what this argument was?
Yes.
And so it was not that McCoy was not followed or Martinez was not followed. It's just it went against the general policy of allowing this type of transcript. I mean, that was the objection.
I grant you that, Justice Lewis.
Okay.
But I will say the judge was ruling consistently as the defense went along, and you've made a valid. Your observations are quite valid about what defense counsel didn't do, but the judge consistently ruled as he went along that this was for the jury to decide, right, not for him, and it was a weight issue. That was his legal ruling. I would imagine that would be his response to any further objection.
Well, but I do appreciate what you're saying, and I do understand being in a trial and getting those kinds of rulings. I've been there, done that. But it seems to me that if you're going to preserve a McCoy or Martinez issue, that you'd really have to say this element's missing and give the trial court an opportunity to address that missing element. Is that not fair?
That's correct.
Okay.
Yes. I think I'm already eating into my rebuttal time.
I assume because you have some strong arguments on proportionality, HAC, CCP. Are you just resting on your brief?
Yeah, and I'll take 10 seconds on proportionality because I don't know if I can get to CCP and HAC. But I will say this about proportionality. If the death penalty is reserved for the most aggravated, least mitigated murders, then this clearly is not the least mitigated. In fact, it's one of the most mitigated. So I'd like to reserve the rest of my time. Thank you.
Good morning. May it please the Court. Leslie Campbell with the Attorney General's Office on behalf of the state. Justice Parenti, you asked about Mr. Davis's mother refuting, and just so that the record is clear, if you'll look at pages 2079 through 2080, through 2080, there is discussion that she is refuting that. However, if you also look at the...
But she did that in the guilt phase?
She did that in the guilt phase, yes. She testified in the guilt phase.
So, okay, so the issue, but I guess the question is, in order to preserve Martinez's objection, the fact that the defendant raised the issue just on this cocaine statement, and again, that was in the, I guess if we rule with you that it was not erroneous to admit the conversation, then the question is there a danger that there was an inaccuracy, there was a significant inaccuracy in this case, and how do you view the application of Martinez here, and even if we didn't reverse on this, what we'd ideally want for the trial court to do, the state to do, and the defense to do, so that we don't have this come up again?
Well, in this case, I believe there was no error in that the jury was instructed several times that they are not to rely on the transcript, that they are to rely on what they see and hear on that DVD. They were told that several times.
And the transcript, but was it just shown to the defense lawyer that morning? It had not been exchanged earlier or produced?
I believe that's when the final transcript was given to him, yes, because they were editing the DVD as they went along. But with respect to Mr. Davis's case, when it became obvious that the transcript clearly was not merely a disagreement on how somebody would hear the tape, but when there was an actual error, the court took the transcripts away and said, you are not to rely on those transcripts. You have the DVD and you have the DVD
but
only.
At that time, the statement about the cocaine had already been heard by the jury, and it was in the transcripts, correct?
It was in the transcripts, the demonstrative aid, it was in that. And it is in the transcript that is before this court, where what Mr. Davis is saying, initially, he's talking about wanting his parents to get $2,000 back from the police. They had taken $2,000 cash at the time of his arrest. And then he reports that he was tasered by the police several times. And he was concerned because he had heard that everybody who gets tasered by the police and has cocaine in their system dies. And he admits, at least the way I am interpreting the tape, he admits that he has cocaine in his system, and that's why the police tasered him. They knew he had cocaine in his system also, so they tasered him.
I mean, but that's sort of the critical question of whether that's accurate or not as to what he said.
But then he just shook it off. And then shortly thereafter, on page 1811, Davis says to his parents, stop quizzing me, I'm already on the downside. So we have several instances within the DVD where he is indicating that there is cocaine in his system.
But I guess the real problem to me is you've got a transcript and you've got a somewhat garbled tape. And when you listen to it, it really isn't as clear as this transcript seems to say it is. And so with the jury having the transcript there, it seems to me they're going to hear what they're reading, as opposed to if there's no transcript there with that language in it, they have to pay attention to the actual words and intonation and all of that that's going on the tape. So if you have an inaccurate transcript, the jury is actually going to think they're hearing what they're reading.
For the court to reach that conclusion, you will have to assume and disregard all of the prior case law that says the jury follows the court's instructions.
Yeah, but when they're actually sitting there reading it, I'm not saying they're not going to follow the court's instruction, but when they're actually sitting there reading it, you're hearing what you think, what you're reading.
And the jury was told to disregard what they read, if they read it, and they were supposed to rely on the tape.
So your position is that even if they listen to the tape again, what they read isn't resonating in their minds, so that's what they're hearing.
I have listened to the DVD several times, and I hear things maybe a little better, maybe not as well. It depends on when you are listening to the tape, what you were listening for.
Is there the general objection on, I guess this was issue 4, was the use of a state-prepared transcript. But what Mr. Patello says is that there was also expert testimony when the state expert, Dr. Butts, testified that she thought that it was psychotic, but it could be cocaine-induced. She relied in part on that he said he had cocaine in his system. Now, was her reliance based on her review of the tape, or did she also have the transcript of it, which then takes something that's not admissible in evidence, and now she's using the transcript? Does this record reflect what she used to determine that he admitted having cocaine in his system?
I believe the record shows that she said she reviewed the DVD.
So now I know every time we say it's a friendly question, this is sort of a friendly question, which is that if somebody then is, she's not an expert in transcription, but if she thought she heard it that way, then at that point, then the judge's ruling is correct that it comes in for the weight, not the transcript. That's different. But
the transcript did not go to the jury, and the transcripts were withdrawn from the jury.
But it does seem to me that if that was a big dispute, that really the defendant needed to give the version or a different version of what was said. How were the experts that they used, were they questioned about this portion of the DVD?
They were questioned about the cocaine.
And what did they say about it?
Several said that they didn't hear that, they didn't know that.
So the state was using it as a fact. In other words, weren't you aware that he admitted to using cocaine on the tape?
Yes.
Well, so it seems back to what the defense should do. If that was a big area of contention, like the biggest, whether he was, cocaine-induced, I mean, at least big for legal insanity, or just a psychotic breakdown, mental illness, that you would expected the defense to have raised this issue early on and come up with their version of what he said. I mean, that's, again, helpful to you. So I just...
It's helpful now. It might not be helpful later.
I know, and that is a problem. And so can you, I guess, the question of what Mr. Patello has now said it could mean, nobody suggested that at the time of trial. Whatever about that he's Jamaican and that the syntax would be something different, about dead off or something like that.
I don't recall that. I know there was discussion that there was, some of this is garbled because they were talking both English and the Jamaican, and I can't remember.
Patois.
So it was going back and forth.
Well, so what did the mother say that he said?
What the mother said was that what she first tried to say was that she was trying to explain what Davis was saying regarding the cocaine and being tasered. And she basically was blaming the officers, saying that, tasered as the police covering for a person dying from being tasered. And that Davis was trying to do the same thing, was trying to make the same connection, which seems, just out of the blue, that why would that come up? She also said that Davis never told her that he had cocaine in his system and that Davis was trying to tell his mother that he thought that the police were tasering him so many times and they would blame it on cocaine. And she never said that Davis actually ingested cocaine. But then again, she didn't know that her son was a drug dealer. She didn't know, apparently, that her son smoked marijuana, which he readily admitted having smoked. And
to her?
Not to her, but he's admitted it on several police reports and to others.
That morning, hadn't there been some discussion, even that morning with her and the defendant, about his erratic behavior, and he had those same clothes on and all that? And then at that point, she asked him about drugs, and he did the use of drugs, and that he denied that even at that point.
Right. But again, he's selling cocaine. He admits to taking marijuana. I believe there was some discussion about ecstasy. The eyewitness to the first killing, Ms. Harrell, said that when he stepped in the door, he was staggering, and his eyes looked like he was on something, that he had either been smoking or taking something. We also have all of the police officers indicating that his actions were as a person on cocaine or on some sort of drugs. So there's plenty of...
well, they said... I thought what they were saying is, I mean, sort of no one disputed that he was acting in a way that was more akin to a potential mental illness. I mean, this is not... I think we've seen a lot of cocaine cases... And I don't ever, I mean, again, I'm certainly not the expert of 14 years worth, but I don't ever remember, and they don't know, that cocaine would have mimicked the kinds of really crazy things that he did in that, and the things he said afterwards. I mean, you don't have experts that really, cocaine experts that say this is all very consistent with cocaine addiction, do you?
Well, what we have is Dr. Butt saying that it's consistent with some sort of drug-induced psychosis.
But what else did she say? I thought she was really not... I mean, this is an expert that everybody admitted... I mean, this was a defendant that everyone admitted was under some kind of psychosis. I mean, not legally insane, but that was the dispute.
He was not acting in character.
But not in character would be... I mean, someone could drink a lot and then they're acting out of character, but... a psychosis is a term of mental health art, isn't it? Or science, whatever.
He was acting bizarrely. He was violent. He was mean. He was vindictive. He was out for revenge. He assumed people were betraying him. He took action in order to satisfy his...
And that's what I'm asking. But Dr. Butts never said, and that is classic sign of cocaine use.
No, she did not say that specifically. But what she did say, and she was, I think, the most thorough of the doctors, looking from before the incident to after the incident, and she used the word... she looked at everything that was the most basic. She looked at what he did before. She looked at the fact that he changed his story depending on who he was talking to. She looked at the fact that the amount of drugs that he was given in the jail would not have, was not a significant amount, that it was more of whether he's can we figure out whether he's malingering? Can we figure out whether...
Oh, and I mean, I don't think they're disputing there wasn't sufficient evidence for the jury to find that he was not legally insane. So I appreciate that. I guess all we're back to here, and we can sort of, is that whether the statement that they interpreted the tape as saying, and I have cocaine in my system, was properly admitted into evidence and then highlighted by a tape, a transcript that actually had that in black and white.
And the answer to that, Your Honor, is that the transcript was taken away from the jury. Whether they saw that first, or even if they were told that that's on the tape, if the judge tells them to disregard it, not to rely on it, we have to assume that the jury followed those instructions, whether they saw or heard something improper to begin with.
Could you address proportionality, specifically the aggravators and mental health mitigation?
We have a very strong aggravator in the prior violent felony, in this case, 2 contemporaneous murders. After Mr. Davis went to Ms. Proby's apartment, accused her of betraying him, and then had her get down on her knees, and he shot her 23 times. He then goes back to a Exxon convenience store, that area, and he somehow gets into an altercation with Mr. Basteo. Either Mr. Basteo cut him off or something. Anyway, he follows that gentleman into the Exxon station where he executes him. He has him at the car. He has him open his mouth, and he shoots him. He then turns and talks to someone else, and then he's distracted by a Mr. Jones that comes by, and for no reason whatsoever other than Mr. Jones is there, he has Mr. Jones get down on his knees, and he shoots him. So we have three murders in succession.
Was the jury instructed on CCP for the next 2 murders?
They were instructed on CCP for all. I mean, it was a CCP instruction, an HAC instruction.
All 3.
All 3. And the burglary. They found 8 to 4 should be the death recommendation for Ms. Proby, and they recommended life for the other 2.
So we don't know, obviously, we don't know what they found on...
Right. We do not know what they found. We do not know the reason why they gave death on one and not on the other 2.
The CCP instruction was read 3 times, once for each of the victims, or once in connection with all victims?
Your Honor, I do not recall. If you'd like, I can point you to those.
I mean, you made the statement that it was for all 3, and I'm just wondering, you made it sound as though that they listed different aggravators or were instructed on different aggravators for each victim, and I didn't know if that's what happened or not.
My recollection is that they were just given the CCP instruction. And with regard to CCP, it is the state's position that CCP is properly found here. Mr. Davis, days before this murder of Ms. Proby, secured an assault weapon. He secured 2 clips for that assault weapon. On the day of the murder...
Well, let's go on that one. What was the facts as to the buying of the gun? What was the testimony on that?
The testimony was that on November 11th, he was acting normally, and there was a friend of his who was selling this assault weapon, and he bought the assault weapon.
So are we saying now, because, did he own it? Was it illegal? Was that an illegal possession of this?
The person who sold it had illegal possession of it.
And he sold it illegally to this Mr. Davis?
He sold it to him.
Well, yeah. I mean, but there's guns in this country that get bought and sold every day. We are certainly never have held that buying a gun or an assault, whatever it is, which are apparently still legal in this country, is a basis for finding CCP.
No, but it is one step, Your Honor. He has secured a weapon. On the day of the murder, he gets into some sort of altercation, which he attributes to Ms. Proby.
I'm sorry, but I thought your question was going to be, are you arguing that at the time he bought this weapon, he was planning to kill someone?
No, Your Honor, I am not saying that. I'm merely saying he has secured a weapon. 2 days later...
But if it's not relevant to CCP, then it's a fact, but it's not a relevant fact.
I believe it's relevant in the fact that he did not have to go out and get another weapon. He had one. He had secured that weapon. He knew he had that weapon. So when the incident comes up...
I thought we normally look at that in the context of he procured the weapon in advance knowing that he was going to take these other steps. That's usually how we look at the procurement of the weapon. But, people have weapons all the time. How do you tie that to whether or not that shows heightened premeditation for the murder?
It shows heightened premeditation in this respect. After he has the altercation, he then goes and gets his weapon.
The altercation with?
With either, it was somebody at a club. He has an altercation with them. Somehow he's either physically assaulted or there's something that happens there.
He gets beat up at a record studio or something like that.
And he assumes, or at least from the conversation that is overheard by Ms. Harrell, where he's talking to Ms. Proby, and when he gets to Ms. Proby's house, he is accusing her of betraying him.
But let's go, because this careful plan of CCP, on the way to Ms. Proby's house, is that on the way is when he gets on the car and starts shooting his weapon in the air?
Apparently so, yes.
And that's is the state saying that's also part of this careful plan that he had to murder Ms. Proby?
I think it just shows anger. He's acting out and showing anger, and then when he gets to Ms. Proby's, he is very deliberate. While he parks,
he parks and leaves the car running.
He parks. He stops the car, leaves it running. While he has the radio on, the fact that he leaves the radio on doesn't mean that doesn't negate CCP. He's deliberate. He goes up to her apartment. He has the gun at his side. He is very serious. He is focused, and he has 2 clips with him. He gets to her apartment. She lets him in. He accuses her again, and then has her get down on his knees before he starts shooting. And he even gets on top of a table and shoots down at her. And he puts 23 bullets in Ms. Proby. At which point, he then leaves.
And she's killed after the first...
The medical examiner could not say whether or not she was actually dead, depending on where he started shooting. If he hit her in the head first...
You've got to prove these aggravators beyond a reasonable doubt, so that's what I was asking.
Right, but the testimony appears to be that she was shot towards the base of the skull first, and then he went down her back with the additional shots. He then leaves and commits the other 2 murders. But it was very deliberate what he did with Ms. Proby. He had a reason for doing it.
And what was the reason?
That it was revenge. He thought that she set him up, and he came to kill her for that reason.
Does the record reflect how long it was between when she related that he said he was coming to kill her in the phone conversation and when he actually got to her door.
The testimonies for the eyewitnesses that were at the first shooting when he was just shooting his gun off near the Exxon station the first time, and Ms. Harrell, it's something less than 15 minutes, probably closer to 5 or 10 minutes with regard to actually arriving at her apartment.
She opened the door?
She opened the door. Now, with respect to HAC, she was told initially that he was going to come and kill her. Yes, he opened the door. She opened the door. But it was definitely at the point where he confronted her with a weapon.
That seemed like an odd thing to do. Any indication why she did that?
She opened the door. Maybe she maybe she hoped to convince him otherwise.
Did she call the police? Because it seems to me there was a suggestion.
There was a suggestion.
After the phone call that the other lady who witnessed all this suggested that they call the police. They didn't. Instead, they text him or something. Wasn't there a text message?
There was a text message
to him.
I think to try and find out.
They didn't leave the apartment,
no.
And she opens the door.
She opens the door.
It just that, again, and we have taken, in many cases, the question is how far does HAC go? You may have an argument that when you kill 3 people, whether it's CCP, HAC, you've killed 3 people, and that's a pretty weighty thing. And the thing that I have here is that obviously the jury thought enough of the mental mitigation to either not have found HAC, CCP for the other 2, we don't know, or that the mental mitigation was clearly these were random, crazy murders. But it does strike me then that this is, and this is always a hard thing, that the mental mitigation here is very strong. It's maybe the derivation of what happened is a little disputed, but everybody agrees that he had some type of a psychotic breakdown, which was completely atypical of him. And I'm thinking of the case, and tell me, I don't know that it's, if you strip away the CCP, HAC, the case where there was the guy that had all that mental illness, and then he thought he saw a cow and he shot somebody. Do you know that? A case that we reduced to life where there had been more than one murder.
I don't recall that, Your Honor, but Songer? If he's seeing a cow, that's something quite different than what Mr. Davis is even saying. Mr. Davis is, even if you want to assume that he is having some sort of psychotic break and he thinks he's doing God's work, he knows he's killing a human being.
True, and that's why he is not, why the jury found him not to be legally insane.
The incident where supposedly he stood on the hood of the car and just fired his machine gun, or whatever you want to call it, when did that take place in relation to these other 2 incidents, murders?
Before.
So he was on the way to her house.
Yes.
When he stopped at an intersection,
yes,
climbed on top of the hood of the car, and just started firing his rifle.
Yes.
Or his machine gun.
His assault weapon.
Okay. Any explanation for that? Why did he do that? Or is it a reasonable?
No reasonable explanation. No.
Explanation?
No, it's just the eyewitnesses saying that this happened.
Was he yelling anything? Yelling out her name?
I don't recall him. There was no testimony that he was talking about her specifically.
So then after he fired the machine gun, the assault rifle, he got back in the car and drove to her house.
Yes. And the police are looking for him during this time. They just never caught up with him.
That seems strange.
People do things that are strange when they're on drugs. They do things when they're strange when they're just having psychotic moments.
In this case, we do have the judge finding the statutory mitigators.
Yes, we do.
So so we've got that established. That again, that's why I said not only wasn't it controverted, but the judge found it, gave it moderate weight.
Yes.
I think that the other part about this question of his intent in murdering her and when it was developed is that Miss Harrell, who was there, they were concerned. He was friends of theirs, and she texts him back to say something as if, "Hey, can't you calm down?" It's like it's almost you have a friend that's getting all worked up, and you just want to just calm down. But he knows she's there. He doesn't tell her to get down on the ground.
No.
He doesn't try to kill her.
No, he's specifically after Ms. Proby.
But, okay, so you don't think that has anything to do with the question of the careful plan? That, the cases we have, like someone goes to Cracker Barrel, they put people into the cooler and they put their hands behind their back and then they methodically shoot everybody that's in there where we've held, that's CCP.
Well, just because he leaves someone alive, or just because he has no anger towards her or is seeking revenge, doesn't take it out of CCP. We're specifically looking at his actions towards this victim, and his actions towards this victim are, I'm going to come and get you, I think you betrayed me, and he follows through. I mean, he didn't shoot anybody else in between, he shot people afterwards, but his focus was Ms. Proby to begin with.
But it's not just, I guess the CCP just doesn't have to do with, I'm going to kill you. It's cold, calculated, premeditated. And so coldness and calculation comes into it. If it was simply heightened premeditation, we would have a different aggravator.
Well, I think it's cold also. I mean, he tells her he's going to come and kill her. I mean, his focus was unwavering. He's coming, and he's going to, to kill her.
But the whole notion that, I mean, even the conversation between Ms. Harrell and the victim was that even in this conversation, he was irate, he was ranting, and this kind of thing. And so it just seems to me that when you put that together, even though he may have focused on her as being the reason he was beat up or whatever it was, that where's the cold aspect of it? It seems to me that's a heated aspect as opposed to a cold aspect.
He's angry at the time when he's initially telling Ms. Proby he's going to kill her. By the time he gets to the door, there's a witness who sees him walk up the stairs. He's not ranting then. He's not talking to himself then. He has the gun at his side, and he's walking with deliberation and with a serious aspect on his face, and he's getting to Ms. Proby's apartment. He then accuses her again. So there's the coldness. He's now thought it through, and he's ready to do what he has announced he's going to do. He gets to the apartment. He makes his accusation. He's not satisfied with her answer, and he follows through. So we have cold, we have calculated, and we have heightened premeditation. I see that I'm 43 seconds over. Unless there are any other questions, I would rely on my brief and ask this court to affirm both the conviction and sentence. Thank you.
I want to go back to Martinez for 1 second.
Could you, on the CCP, did they instruct separately for all three victims?
I don't remember if they did it 3 times.
But CCP was asked for all three.
That's my understanding, correct. Yes.
On CCP, does the law require that there be an absence of anger?
No, I don't think so. I think you could have CCP. I don't think they're mutually exclusive. But I think, here, just on CCP, the prosecutor's theory was that this was murder based on rage and unrestrained passion and anger and uncontrollable anger, whereas CCP requires careful plan and prearranged design. I suppose you could be angry and have those things, so I answered it that way. But here, there's no careful plan. There's no prearranged design. You don't get on top of your car in the middle of an intersection that has the green light and the cars honking their horns at you and shooting your gun off into the air.
Did he call her and tell her he was going to kill her?
That's what she testified to.
Did she call him, did she not?
Yes.
He didn't call her.
Right, I think so.
She happened to call him while he was sitting on the curb.
Yeah, I think that's what made it click in his psychotic mind that that's his mission to kill her. Yes.
And then she texted him back after the call.
Either that or her friend, Harold, testified. Your homegirl, Tish. I forgot what the next line was, but it was I really think very suggestive that they didn't take this seriously because, and I think, it was such a known fact about Rston Davis that he was a peaceful person. This was so out of character. And that's frankly what Dr. Butts testified at the Spencer hearing. She saw a direct link between this mental mitigation. Granted that she thought the better explanation was the drug-induced psychosis. But she saw that this was a direct link between that and the murders. It was completely out of character.
You were going to say something about Martinez.
Yeah, I just wanted to say, because the state makes a point about the cautionary instruction that is mandated in Martinez and McCoy, and the judge gave one here. But I think it's important in Martinez, this court said that those cautionary instructions are only viable when the tape is clear enough for a juror to detect that the tape is at variance with the transcript. So they're not going to work. These cautionary instructions, these focused instructions aren't going to work unless the recording is clear enough so that the jury can disregard the transcript that they're being given. And I think that's a classic case here of this portion of the DVD about the cocaine in system was not clear enough.
But that's not the objection that was raised at the trial court, was it?
No.
See, that's the problem. We come and meet ourselves again. But that's...
Well, I was just addressing that
I appreciate that.
The jury instruction took care of any error that occurred here, and it doesn't. Those don't work in a situation like this.
Well, those are applicable in all circumstances so that the jury will not rely exclusively on a transcript, that the evidence is the recording.
Yeah, I'm just saying when there is something that the transcript shows something incriminating that can't be clearly heard, it's not enough just to tell the jury, rely on your own view of the transcript.
Right, but you need to object to it and say that, and that's what that didn't happen here.
I agree. And
just to be clear,
yes.
Now, you said that during the testimony of one of the doctors that there was an objection to the transcript on the basis of a dispute with him having said he was using drugs. Now, I thought that's what you said.
Yeah,
and it certainly seems to me that even at the time they were giving the jury the transcript, there was an objection based on it not being an accurate.
Yeah, that's correct.
Well, tell me what.
Yeah, that was during Dr. Ribbler's testimony, and this is at volume 11, page 1363. And this is when they're first getting, and as I said, they are editing this transcript as the trial is going along, and different versions are being given to the defense as it's going along. So I think the defense has some claim that they're being treated unfairly.
What is the evidence on that? Because as I understood it, the officer who was in the room and monitoring had gone through this and did his edits. Are you saying that there's some other version, some other place?
I am.
Is that clear in this transcript?
Yes. They sent this tape, this DVD, to some company. First he said Kalamazoo. I think he was just joking, but he said, I think it was Arizona, for a transcription company to do it.
All right.
They got that version. I think that's the version that the defense attorney's talking about on Wednesday, June 24, when the state's asking Dr. Ribbler about this portion of the DVD, about this portion of the DVD.
But supposedly, at that point,
he says,
the officer had gone through it and had made...
Not at that point, no. Defense gets a transcript from the state, and he says, it does have words to the effect of something about cocaine in his system. We are not acquiescing that that's what was said, It's obviously someone interpreting it. So that's right. And he objects each time his experts are asked about that portion. And he objects when they bring in the transcript. So just on proportionality.
You're over a little bit. If you can sum up in 1 minute.
I'd just like one sentence about proportionality and the fact, yes, there's 3 killings here, 3 murders. But in Alameda, he had 2 prior murders that occurred before the murder for which he was sentenced to death. And this court said because of the substantial mental mitigation in that case, death was disproportionate. So I'd rely on that for proportionality. Thank you.
We thank you both for your arguments. We now go to the final case on today's docket, Swafford versus the State of Florida.
Good morning, Your Honor. Still morning. My name is Terry Bakis. I'm here representing Mr. Roy Swafford. Your Honor, if this court is truly a court of equity, then Mr. Swafford's case is the perfect storm of injustice. We've been before the court many times, and each time we've been before the court, we've brought new evidence that shows Mr. Swafford is innocent. In this case, we were on remand to the trial court for DNA testing. In fact, you had to remand it twice. And we had an evidentiary hearing on one paragraph of that 3.851 motion concerning...
When you say he's innocent, are you saying innocent of the murder or of the sexual battery?
I'm saying innocent of both. And I think the evidence that we have now, that the trial court found that we could not have discovered before now, which is the first prong of the Jones test, and the court was correct in that finding that. Where the wheels fell off of the trial court's order is on the second prong of the Jones test, where he said that the evidence of the acid phosphatase, negative acid phosphatase test, was not enough to show that he should be exonerated. The problem is, in the trial court's analysis, is that he excised only the negative acid phosphatase test from his analysis of all the evidence and just compared that to the evidence that came out at trial.
It seems to me that I would certainly might buy your argument if you were talking about the sexual battery, but I don't. How do you connect that the negative acid phosphatase test to the murder?
Well, first of all, it's the underlying felony for felony murder. It was, and keep in mind, this is the only other charge here besides the robbery that he was acquitted of. So we have first-degree murder, then we have sexual battery. The sexual battery was used from beginning to end in this case as the motive for the crime.
And there's not sufficient evidence that this was a premeditated murder?
No, particularly in light of the evidence that's come out since the time of trial, which was the mistake that the trial court made. The trial court did not look at the evidence that came out from the original 3.850 motion that dealt with ineffective assistance of counsel.
Well, why don't you then just tell us how this test demonstrates that he is not guilty of the murder? That is the connection that I am not making here.
Okay. The negative acid phosphatase test was the linchpin of the medical examiner's testimony with regard to why the injuries happened. He gave the testimony to the jury about that as an expert, saying that the acid phosphatase test showed that the victim had been raped. Raped was argued by the prosecutor later on, but Dr. Botting testified that the positive acid phosphatase test showed that there was a male organ in the orifice and that seminal fluid had been ejaculated. Mr. Keith, who was an FBI analyst, also an expert, testified to the jury that even though there were no indications of sperm in the acid phosphatase, test that they did, that still indicated the presence of semen. These things together were the linchpin of what the murder was. It was the motive for the murder. It was why they said Mr. Swafford went to the FENA station, abducted this poor woman, and took her.
We know that you don't really have to prove motive in order to prove murder. I just really need you to tell me why there is not sufficient evidence of murder in this case. Whether you're going to base it on the test
solely on the trial evidence or on all of the evidence, which is cumulative, which is what the proper standard is.
Whatever way you want to do it. Just tell me why there is not sufficient evidence of murder here.
Well, we have to look at everything together. The last time we were before the court, we looked at Brady information that cast doubt on the testimony of the co-perpetrators, of the other crime that had happened prior to this one in Panama City. These individuals were, we found evidence of bias. In fact, one was seeking a reward he actually called to see if he could get a reward before he came up with evidence to show that.
What about the gun, the ballistics test?
Okay, let's talk about the ballistics test.
Do that. Okay.
All right. If you go back, and we're talking about cumulative evidence, go back to the original 3.850 motion in this case in 1990. There was a ballistics expert that testified for the state about the projectiles that came from the gun. He made the conclusion that there were different bullets in the gun, and I think 4 of the projectiles were tested or looked at. Defense counsel, who we had alleged in that motion was grossly ineffective, had retained his own ballistics expert to actually tell him that that was actually incorrect, that there was perhaps only one projectile that possibly could have come from that gun, but it was by no means conclusive. And trial counsel, of course, did not present this testimony at trial for some unknown reason. And, of course, there are, in conjunction with the gun, the contradictory testimony about how the gun came to be in the possession of the police. The bouncer actually brought it to him.
It was in one bathroom or the other. I mean, okay.
That's.
But the weapon is tied to Mr. Swafford, is it not? From Nashville, he stole it from a couple in Nashville. He seemed with that weapon. I'm sorry.
The testimony was from Mr. Harper. Mr. Harper, that the gun was in Mr. Swafford's possession and that was the gun, or a gun like it. He came into court and said that was the gun, and then later on his testimony, well, it looks like the gun. It was never as cut and dried and definitive as the state led the jury to believe. So if that's the...
Was this gun not stolen from Nashville?
It was stolen from Nashville.
Is that where Mr. Swafford is from?
Yes, it's also where Mr. Walsh drove through and sold some guns. Yes.
Was Mr. Nash not seen with that gun, I guess, the day after the murder?
Mr. Swafford, you mean?
Swafford, I mean, yes.
Yes. Mr. Swafford, the testimony about Mr. Swafford having possession of that gun also came from Mr. Harper and the Johnsons. those people that had a bias against Mr. Johnson and had reason to say that. It was not as cut and dried as a jury was led to believe.
When we look at cumulative, what do we do with the majority opinion in 2002, which essentially says you can't consider what Letts says about Walsh because post-conviction counsel wasn't diligent in finding Letts? What do we do with Letts's testimony?
Well, I think that you have to look at it from the perspective of the diligence standards, which there have been some cases that have come down the pike since then that says that the diligence standard is the same for post-conviction counsel as it is for the trial counsel.
Well,
but at the same time saying...
No, you're not... Assuming we're not revisiting Swafford, the 2002 opinion, unless somebody says Martinez requires us to now look at this. Do we consider in a cumulative analysis what Letts says about Walsh? Because it's pretty compelling evidence that the gun that was thrown out by Walsh and not Swafford. I mean, that's why I voted with the dissenters that I thought that this defendant needed a new trial. We're not talking about whether he gets off. And that now with the issue of sexual battery, it seems compelling. But what I'm asking you as an officer of the court, not as that equity can't just be thrown around unless you're on the U.S. Supreme Court and like they did in Martinez. But here we're in a court that we have precedent. So how do we consider that evidence if we are bound by the 2002 opinion that says you can't consider it?
Well, I don't think you're considering it as like a precedential opinion against an opinion. You're putting all of the facts that have been learned into a big kettle before you're considering how the acid phosphatase figures into this. So you have to consider all of that evidence.
But it seems like to me if that's a fact that we say should not be considered because of lack of diligence, that's different than a fact that would not have led to relief because it was insufficient to show prejudice. Wouldn't you agree? I mean, that's what if you've got facts that weren't considered or that were considered but did not lead to relief because they were insufficient to show prejudice, then those get thrown into the pot and it has to be reevaluated in light of all those facts to determine whether in fact there was prejudice. But here, this is something that was barred. It could not come in because of the lack of diligence, and isn't that different?
I don't think so. I don't think so.
I didn't think you would.
Well, here's why. Here's why I don't think it's different. Because we're not looking at it in the context of is this admissible or is this not admissible. We're looking at this as a whole, what trial counsel could have done, what they should have done. And part of the ineffective assistance of counsel on which Mr. Swafford never got an evidentiary hearing was that he did not discover these other suspects that were either in the sheriff's office file and were not disclosed by the state. So you may have said, well, on the basis of Brady, these don't come in. But under the auspices of an ineffective assistance of counsel claim, they do come in because all of the things that were in the original post-conviction motion have to be taken.
Well, I guess the best way and I don't know where legally how it goes, but it would be that, and you're not, if the evidence that he may not have committed a sexual battery is not enough to give him a new trial, but if it is enough to give him a new trial, then nobody would argue that the testimony of Letts, all that would obviously be able to come in a new trial. Well, and so the question is, as we evaluate this, do you get to where there is a new trial without evaluating other evidence that has been developed since the first trial?
No,
And can you get there without the Letz's testimony?
Yeah, I think you can.
And that would be, you're going back to what the other suspects or the other people that now have credibility issues.
Right, and the reason being is that when I go back to my new trial, I don't have to prove that Walsh did it. I have to prove that there's a reasonable doubt that Mr. Swafford didn't do it. And that's a difference. It's a huge difference.
We know what the difference is. What I'm asking you is, though, you still have to get over the hurdle of whether now with this additional piece of evidence, we are now at the breaking point that Mr. Swafford, in the interest of justice and his potential innocence, deserves to have another trial.
Right.
And so what I'm asking you in that, because you wouldn't be excluded from introducing Letz at a new trial.
Right.
To say
and that would be up to the jury to evaluate whether they believed him or not.
But if we have said that it wasn't, that the due diligence precluded that alone from being newly discovered evidence, and that we therefore don't, just let's assume that we said we can't now consider it in a cumulative analysis, and maybe that's right or wrong. What other evidence can be considered in the cumulative analysis?
Well, I think like I said before, all of the evidence from the original 3.850, all of the things that they did not get a hearing on as far as ineffective assistance of counsel, if you look at the penalty phase alone, the only mitigation that was presented in this case was an affidavit that's 2 paragraphs long.
But you're looking for a new guilt phase. You're not. Well, this isn't going to the. Are you?
Right.
So
because I think this goes.
But was there any in the 3.850 or any of the successive claims? What else was actually found by this court to either be a Brady violation, ineffective assistance of counsel, or newly discovered evidence? Anything else?
Well, like I said, I don't think that's the standard.
But whether you think it is or not, I'm asking you a question. Is there anything that this court has found to be evidence that wasn't discovered, that should have been discovered, that we should be that would qualify as a cumulative type of analysis?
Well, I think just from the evidence in the DNA case itself, you have the evidence that shows that there's a hair in the victim's panties that was analyzed, and it was not Mr. Swafford's. I think that's a big thing. You have the really almost all of the things about the ballistics. They were not as cut and dried as the state would have had you believe it.
So you're really saying that you think through all of this, you've attacked every part of the underpinnings of the state's case.
Every part. I can't think of a single piece of evidence that has survived the last 20 years of litigation, that if I were going in to do a new trial, I would have that at my disposal. And I think that's the point of the second part of the Jones test, is that you have to look at what competent counsel could have done with this evidence, even the acid phosphatase and the DNA stuff, leaving out everything else. Because that was the basis. That was what they were arguing was the motive for the case. And if you don't have motive for the murder, then you don't have a case. One juror is all we had to convince to have a reasonable doubt. And I would ask you all to look carefully at the closing arguments of Mr. Cass at penalty phase. Mr. Cass argued in penalty phase for about 2 pages about the mitigation. The rest of his argument was about lingering doubt. Now keep in mind that the jury vote was 10-2. 2 jurors voted for life. And after reading the oral argument, if you think that those 2 jurors were voting on the mitigation, then by all means do what you think you should do. But after you read that argument, you will be convinced, as I was convinced, that they were voting on lingering doubt. And I think if we had within the mix the negative acid phosphatase testimony, which keep in mind came to the jury through 2 expert witnesses, 2 experts, an FBI analyst who was formerly an FDLE analyst, and Dr. Botting, the medical examiner. And
you're now well into your rebuttal time. You've got a little less than 2 minutes.
I'll reserve the rest of my time for rebuttal. This case is 30 years old. This case has never found any piece of evidence to be Brady evidence, ineffectiveness, or newly discovered evidence.
Well, that's because legally there have been bars. My concern is that this new evidence that this was, on the sexual battery is really enough to put this over the top. And I appreciate you as an advocate for the state do not want to subject a victim's family to another trial. But I think the question is, when we look at the whole history of this case, and there are very few cases like this, Hildwin keeps on coming back and there seems to be more evidence each time, but very few cases have this, at least that I've seen. And what we've got is we start out with suspects that included Walsh that were not revealed. Now, we may have said they weren't obligated to reveal it. Well, then that puts that counsel was ineffective in not revealing or not finding Walsh. Then we have now the issue that the gun absolutely connects this defendant. And then we have real questions as to whether this gun may have been one that was Walsh's gun, and that he certainly had the opportunity. Now we've got the sexual battery is in question. At what point does looking at the whole picture post the original trial get to a point that whether you call it would probably produce an acquittal or just undermining confidence that in the interest of justice, the defendant deserves to have a new trial with the evidence that is properly before the jury that we now know exists?
Your analysis is viewing the evidence in the light most favorable to the defense. You must view it in the light most favorable to the state. The gun is conclusively tied to Mr. Swafford. He had it when they came down. He stole it in Nashville. His friends saw it with him. After the gun was seized by the police, he said he was upset that they had taken the gun. There was no time lapse at all.
You made a lot of statements there. Could you go through the evidence in the record that supports those things?
Yes, and they are in the brief. They cite to the direct appeal record. There was testimony that on the way down, well, first of all, they had the serial number of the gun in Nashville from where the gun was stolen 3 months before the trip to Daytona Beach. Mr. Swafford drove down with 5 other people. 2 of them testified they saw the gun in the car. The night that they were at the Shingle Shack, 2 of those people, the same 2 people that knew Mr. Swafford had the gun, tried to rip off a drug dealer. Mr. Swafford pulled his gun on them. The police were called. Mr. Swafford put the gun in the Shingle Shack bathroom. The police seized it 5 minutes later and arrested all 3 of them for aggravated assault. The gun was in evidence for approximately a year until Roger Harper, one of the arrestees for aggravated assault, said that gun may be the murder weapon. They then tested the murder weapon, and it was conclusively the gun that matched the bullets. Now, as far as any direct appeal evidence that we're re-arguing, and this is also outlined in the brief, Roger Harper, the ballistics, all that evidence was resolved on direct appeal. The jury resolved any conflict in the evidence. Any evidence about any impeachment evidence or dispute in the evidence, that's been resolved by this court on direct appeal. In the first post-conviction motion, this court said, and it's attached to the state's brief so that you can see the trial court rulings on each issue, there is no Brady evidence in this Walsh-Letts-Levi business. In the third post-conviction motion, this court said there...
I think you're going...
Past the gun.
other? I mean, that's strong evidence, certainly. Was there any other evidence that you want to relate as to the gun?
I think the question was as to the gun, and that is in the state's brief. That is also in the briefs on direct appeal, and this court found on direct appeal that gun was conclusively linked to Mr. Swafford. Now, also on direct appeal, and the issues that are now being argued as creating reasonable doubt,
They're issues from direct appeal. They're arguing impeachment evidence, which was resolved. The issue about Let's Levi Walsh, this court affirmed the trial court on the first post-conviction. That's not Brady evidence.
I think what we do, what Kyle's and the other cases do, is that what you're looking for on newly discovered evidence is you take the new evidence and then you look at what would be admissible at a retrial. So, for example, if we always had an eyewitness that said they saw Swafford shoot the victim, and that evidence was never impeached or questioned, we would say, well, that's still going to come in. So, you know, despite everything else you're saying, the case doesn't change, or there's a photograph of him, a video of him shooting. Let's just say so everything else you're saying really doesn't, when we look at it cumulatively. But we look at, if there was a new trial, usually what the state is saying, nothing will have changed. And what I'm asking you is, it seems to me, and maybe there's some smoke and mirrors here, and that's what your assertion is that with the existence of Walsh, who was at least unknown to the original defense lawyer, the addition of Letts, who has some highly incriminating statements about, it just so happens that Walsh was also in the shingle shack and had a gun, and so forth. And now we have that the sexual battery, which was another linchpin, that it does look like the state's case. You know, it's not an issue of whether you could still get a conviction. Obviously, they're not saying there's enough to grant a judgment of acquittal, but that it casts enough doubt as to the evidence that Mr. Swafford deserves a new trial.
Except that you're looking at the evidence which has been discredited, rejected by the jury, rejected by the trial court in this court.
I thought they didn't know about Walsh. I thought Walsh wasn't yet. We don't know. In other words, did the jury have Walsh as the suspect?
That was the first post-conviction.
I'm just asking. So they didn't. And there was a composite.
The first post-conviction where this court found it was not Brady evidence. And then the affidavit of Mr. Letts, a jailbird who was trying to point the finger at Mr. Walsh, arose in the third post-conviction, and this court held it's not newly discovered evidence.
But why did we held that? Because we said there wasn't due diligence. We didn't ever reach, the majority didn't reach the question of whether it probably would have given an acquittal to Mr. Swafford.
And let me point the court
Is that correct?
Yeah.
And the Brady, we said it wasn't an obligation of the state to produce it. We didn't reach whether it undermined confidence in the outcome, did we?
You did not, because it was not Brady evidence and it was not newly discovered evidence.
So it was then ineffective assistance if they didn't get these suspects.
There was no ineffective assistance. And this court has held that. So unless you want to undermine the finality of convictions and turn all the case law of this court on its head, let me point the court to Preston. It's 970, and I'm on page 804. It says, this court has already denied each allegation of error on direct appeal and the post-conviction motions. Therefore, the cumulative error claim files. When you have no Brady evidence, 0, you have no newly discovered evidence, 0, and no ineffective assistance of counsel, 0, we add that up, it's still 0. Remember, as far as the sexual battery, if there's any concern as to that, defense counsel conceded the sexual battery. Somebody asked about, was the sexual battery, there was no evidence that Mr. Swafford's DNA was the sexual battery. The theory of defense is, Mr. Swafford did not have a motive to commit sexual battery. He had been with a woman for the 3 hours preceding that. He did not have time to commit the sexual battery. Defense counsel said sexual battery was committed, but not by Roy Swafford because he had no motive and he had no time to do that. That was trial strategy. This court has already said that was effective trial strategy. Also in the first
But I'm not sure I understand something. Were you saying the defense lawyer, if he knew there was no evidence of a sexual battery, would still make the argument and concede there was a sexual battery?
That was the issue on the first post-conviction motion. It was issue 3 in this court. First, let me find that. It was the 1990 issue 3 was that trial counsel was ineffective for conceding the sexual battery for not challenging it. Number 13 was the state did not prove in first post-conviction. The state did not prove sexual battery because there was no sperm. Now, the FDLE report said there was a chemical test, which is a screening test, which was positive for acid phosphatase. However, because there was no sperm, semen could not be conclusively identified. Keith Paul testified to that at trial. Then he was asked, is acid phosphatase evidence of semen? Yes. Defense counsel came in, and there are some certain mistakes in the initial brief. Defense counsel was asking these questions about prostatic, from a man, acid phosphatase, meaning a male organ was there. Defense counsel, through Mr. Paul, and again through the medical examiner, asking about prostatic acid phosphatase, was establishing a sexual battery, because that means Roy Swafford could not have done this. He had no reason to do it, and he didn't have time to do it. And this court has addressed that as ineffectiveness and said that is a reasonable strategy. And defense counsel testified that. When he was testifying on the third post-conviction motion, and we attached that to the brief, that was the way to win this case. Because there was 44 minutes for him to abduct Brenda Rucker by gunpoint, travel 6.5 miles, take her clothes off, take his clothes off, have penetration with a male organ in 2 locations, reclothe him, reclothe her, march her out into the forest, shoot her 9 times, and get back to the campsite 1.5 miles away in 44 minutes. And the defense attorney had this down to the minute. This could not have happened. In addition...
Do the convictions for sexual battery and murder rise and fall together?
Not at all. Not at all. Because, remember, the sexual battery, if the sexual battery fell out, the jury acquitted Mr. Swafford of robbery. If they acquitted him of sexual battery, the murder is completely independent, because there was... The murderer committed the sexual battery, not that the sexual battery was committed by the murderer.
Your opposing counsel says it's such a theme of the case, though, that if you don't have a sexual battery conviction, then you need to reverse the murder.
See, that was the defense theme. The defense theme was that whoever committed this murder committed the sexual battery, and Roy could not have committed, Mr. Swafford could not have committed the sexual battery. That was not the state's theme, because there was ironclad evidence of the murder. He would have driven right past there. The stripper from the shingle shack saw him drive down US 1. To get to the park, he would go right past the FINA station. There's opportunity. The gun ties him to it. After statements, he made statements to Ernest Johnson, we'll just go get a girl, do whatever we want to, and we'll never get caught. It bothers you for a while, but then it doesn't bother you after a while. He escaped during the pendency of his trial, took 7 hostages at a hospital, called the newspaper and said, we're murderers. We're murderers. You better take us seriously. There is, the state tied this murder together. Now, if the sexual battery fell, there goes the defense theory of defense. And this court said in the in footnote 2 of the 1990 first conviction Swafford that the abduction supports the during a felony aggravator. So it wouldn't affect the sentence either, because we've got the kidnapping. So take out the sexual battery, who does it hurt? It hurts Mr. Swafford. A couple other points. There are some discrepancies in the initial brief. On page 45, the initial brief says that Swafford was not the source of seminal fluid, therefore he is not the perpetrator. Semen was never conclusively identified. There was testing, there was no sperm, no one was identified, and there could not conclusively be semen. So that's a misstatement. As far as the white towel that did not have any evidence of Brenda Rucker on it, that evidence came from Mr. Letz's van, not from Mr. Swafford's car, as it says in the brief, and not as it was said by the victim. In evidence is an outline of defense counsel. The state objected to about 500 pages of FDLE background material coming in. Within that packet was work product of defense counsel. There are two very large discrepancies on this if the court is looking at these. The white towel was seized from another car, not Mr. Swafford's. Any place that says van, that's not Mr. Swafford. That's page 1487, 1489. Also the van. Hairs in the van, which did not have Brenda Rucker on it. Also that the testimony, which is miscited in the initial brief that's labeled prosecutor, was trial counsel, page 39. And if the court doesn't have any further questions on this, of course, the state's position was that there was not due diligence on the acid phosphatate testing because the evidence at the evidentiary hearing established this could have been done at any time. It was done in 1982, so we had asserted due diligence. The trial court found that it was newly discovered. However, it was not material for the reasons that we've outlined. One more point. The court on direct appeal found that this was a premeditated murder. That's 533 Southern 2nd 270 at page 277. And also the court found CCP. So it was premeditated murder. If there's no further questions, I'd ask the court to affirm the trial court.
First, Your Honor, with regard to the sexual battery not being the motive for the crime, that's certainly not what the prosecutor's story was at trial. They did argue it was premeditated. They also argued sexual battery supported 3 aggravating circumstances.
But what she's saying is that the sexual battery actually was what the defense lawyer's strategy was, that he couldn't have been that busy, having just spent 3 hours.
Well, actually, the defense counsel at the Brady evidentiary hearing said that the theory of defense was reasonable doubt. He didn't say that. And the sexual battery was a linchpin of the case. It was what they were pinning their expert testimony on. It's what the jury heard. The jury actually took this inaccurate information, and that's what they did. And if you look at House v. Bell, which I think is the case that's most closely associated with the facts of this case, in House v. Bell, they talk about this exact situation and about how when the jury considers a sexual battery, which is a part of the case, when you take that out of the sentencing calculus, you have to start over again because the jury has considered it. You can't unring the bell, especially on sexual battery. Also, with regard to the standards for evaluating evidence that's been previously decided one way or another by this court in previous opinions, if you look at Hildwin on page 796, well, actually 796, it talks about that the trial court must evaluate the newly discovered evidence in conjunction with evidence that's presented at all prior evidentiary hearings and evidence presented at trial. That means regardless of what this court has ruled about its admissibility, about whether it was found with due diligence, you still have to consider that evidence because that's evidence that if a new trial is granted, competent counsel would use to try to establish a reasonable doubt to that one juror. One juror is all we're looking at for a guilt phase in order to create a reasonable doubt of guilt in the jury's mind. And that's the most important thing, I guess, to take away from this is one juror as a whole, considering inaccurate information, could have made a big difference in this case because it was a highly circumstantial case, and that's the whole crux of the problem, is that you could make just as much of an argument that Mr. Walsh's circumstances fit this crime as you could Mr. Swafford's. And when you have a case that's that tenuous and you have trial counsel that is that incompetent, You have to look at it all in a whole. That's what Hildwin says, it's what Jones says, it's what House v. Bell says, and that's what this court should do. I strongly recommend that you use your equity powers to correct the injustice and give Mr. Swafford a new trial. Thank you.
We thank you both for your arguments. That concludes this session of the court.